pleasant day to each and every one of us, especially our law students and future pañeros and pañeras watching across the Philippines. Welcome to Central Books' Best Pre-Week Ever, where future lawyers meet the best legal minds in the country. I am Mary Jane Matalog and I will be your host for today. So before we begin, allow me to give a quick overview and description of this year's bar operation. So the part 3 of the 2025 Pulse Bar Lecture Series is a discussion of the latest cases decided by the Supreme Court presented by the Philippine Association of Law Schools in partnership with Rex Education and Central Books. We're proud to continue this tradition of excellence, bringing together top educators and practitioners to help you prepare for the bar with clarity, confidence, and purpose. This is just one of many pre-week lectures with Central, as we also have scheduled for legal and judicial ethics and taxation. So for updates, please do not forget to like and follow the Facebook page of Central Books PH and Philippine Association of Law Schools to remain updated with the dates and speakers for each lecture. And of course, just a reminder, we really and strictly discourage the recording and reproduction of this lecture series for personal gain, as you can rewatch it again as you want to do so. So please don't record this lecture. We would also like to acknowledge and recognize our dear partners and sponsors for this initiative, Rex Education and Central Book Supply. So, without further ado, it is my honor to introduce to you our esteemed lecturer for today. Judge Janice Andrade-Udarbe is currently the presiding judge of Regional Trial Court Branch 57 in Lucena City, Quezon, serving as the Special Commercial Court and Cybercrime Court. Previously, she presided over the Municipal Trial Court in Tagkawayan, Quezon from 2013 to 2020. With over a decade of experience as a trial court judge, Judge Udarbe is also a professorial lecturer at the Philippine Judicial Academy and a regular MCLE and Bar Review lecturer for Remedial Law. She has taught remedial and criminal law at various law schools since 2014 and has authored an 8-title remedial law book series. She holds a Bachelor of Arts in Psychology from De La Salle University, Dasmariñas, a law degree from Arellano University, and a Master of Laws from San Beda University, Manila, specializing in electronic evidence in the Philippines. Everyone, let's give a virtual round of applause for Judge Janice Andrade-Udarbe. Good day po, Judge.
All right, good morning. Good morning, everyone. Today's schedule for bar subjects would be evidence and special proceedings, and I hope you will have the energy to listen to this topic. So, based on survey, sa isang bar exam, 2 to 3 questions usually ang tinatanong sa evidence and sa special proceedings, more or less 2 to 3 questions. So it would be helpful for you to listen dito sa review na lecture, and somehow you'll get some tips on how to answer this bar subject or this subject in the remedial law, which is a bar subject. So let's start. So what is evidence? Ready? Evidence is the means sanctioned by these rules of ascertaining in the judicial proceeding the truth respecting a matter of fact. This is found in Section 1, Rule 128. Now, the best way to answer whenever word is being asked in the bar exam, so whenever you are confronted with this kind of question, you should answer it based on how the rule defined the word. So, best pa din talaga yung sanay kayong memorize ng mga definitions, more or less. Pag kaya pa ng kapangyarihan ninyo, be familiar with the definition of evidence. Alright, so The rules of evidence shall be same in all courts and in all trials and hearings, except as otherwise provided by the rules, but it will not be applicable to election cases, land registration, cadastral naturalization, and insolvency proceedings, but also it may be applied by analogy or whenever practicable and convenient. Now, question, is the rules on electronic evidence applicable to criminal cases? So aside from the rules on evidence, we have rules on electronic evidence, which was promulgated by the Supreme Court in relation to the rules on E-Commerce Act. So, and originally, in 2001, the rules on electronic evidence is not applicable to criminal cases, but in 2002, when the Supreme Court expanded the rules on electronic evidence, as applied in the case of People versus Inojas, the Supreme Court appreciated the text message, which is electronic evidence. And this is one of those cases where the Supreme Court applied the rules on electronic evidence in criminal cases. So the answer is yes, the rules of electronic evidence is applicable in criminal cases. Now, what are the instances when evidence is no longer required? So when the pleadings in a civil case fail to tender an issue, judgment on the pleading will ensue according to Rule 34, stipulation of the parties when a fact is subject to judicial notice, judicially admitted, and when the law or rule presumes the truth of a fact. So of course, as mentioned a while ago, the meaning of evidence, you have to prove, you have to present, you have to prove a fact in this subject, in this kind of in evidence, but there's no need for evidence if these items are present. So in case of the answer fails to tender an issue, then you will proceed with Rule 34, the application of Rule 34. If there's stipulation, of course, if the parties agree to stipulate on certain facts, then no need for evidence. If there is judicial notice under Rule 129, so there are items in the rules of evidence, such as Rule 129, where evidence is not required. So judicial admission, and there's a presumption of the truth. So no proof or no need for evidence. So proof is the product of evidence, while evidence is the medium of proof. You already know this. So two famous words in evidence, factum probandum and factum probans. Factum probandum is the fact or proposition to be established, while factum probans is the fact or material evidencing the fact or proposition to be established. So when we say factum probandum, it is the fact to be proved, while probans, it's a probative or evidentiary fact tending to prove the fact in issue. Example, in a suit involving damage to property caused by the negligence of the defendant, the factum probandum is the negligence of the defendant that caused damage to the property of the plaintiff. The probans, the factum probans, are the pieces of evidence, whether it be object, testimonial, documentary, to prove the negligence of the defendant. Now, in the civil cases, the factum probandum is the elements of the cause of action, of course, usually denied by the defendant, while in criminal cases, factum probandum refers to the matters which the prosecution must prove beyond reasonable doubt in order to justify conviction. Okay? So let's proceed now with admissibility of evidence. If your evidence is not admissible, it will be not useful because the court will not consider your evidence. So there are two rules in the admissibility of evidence. So under the rules, evidence is admissible when it is relevant to the issue and is not excluded by the Constitution, the law, or these rules. So we have a formula here. Relevancy plus competency equals admissibility. Admissibility of evidence, of course, in 2019, the rules on evidence was amended, and it included some provisions of the Constitution. Just to repeat, evidence is admissible when it is relevant to the issue and is not excluded by the Constitution. So ito, dinagdag ng Supreme Court sa definition na admissibility of evidence. Why? Because we have the exclusionary rule in the Constitution. For instance, Section 3 in relation to Section 2 of Article 3 of the Constitution. So, if you can remember the fruits of a poisonous tree, diba? If the evidence is a result of violation of that constitutional right of a person, then it is inadmissible in any proceeding for whatever purpose it may serve. So, for whatever purpose or whatever proceedings. So, importante, admissible ang evidence. And when is it admissible? When it is relevant and competent. The new rule deemed it to include the Constitution in Section 3 because it also provides rules for excluding evidence in the Court of Justice. So, the difference between the two, relevancy and competency. When we say relevancy, it is the relationship of evidence to the fact and issue. If the evidence will tend to prove the fact and issue, then the evidence is relevant. If there's no connection at all, then the evidence is not relevant. The test of relevancy is logic and common sense. While competency naman, it is one that is not excluded by law or by the rules. The test of competency, of course, the Constitution, the law, or the rules. So, dalawang formula yan. Relevancy, or dalawang words na magbubuo ng ating formula. Relevancy plus competency equals admissibility. Now, question. Armando was charged for killing Boboy. The information was captioned as murder. However, the information failed to allege circumstances which would qualify the killing to murder. During the trial, the prosecution introduced evidence of treachery. If you are the counsel for the defense, what procedural action will you do to protect the interest of your client? So, murder case, the information did not allege the qualifying circumstances of murder. So, possible answer, if you are the counsel, I will object to the presentation of evidence of treachery on the ground of relevancy. The qualifying circumstances was not put as an issue for failure to allege the same in the information. Under Section 8 of Rule 110, it is required that the qualifying and aggravating circumstance must be specified in the information. Let's proceed now with collateral matters. Is it allowed? As a general rule, no. Collateral matters are not direct evidence. It is just additional or auxiliary evidence to the fact and issue, except when it tends in any reasonable degree to establish the probability or improbability of the fact in issue as provided specifically under Rule 128. Now, ito na, yung medyo importante na sinasuggest ko na kailangan familiar kayo, alam nyo yung difference ng admissibility of evidence as weight of evidence. So, if this will be asked in the bar exam, what's the difference between admissibility of evidence and weight of evidence? So, admissibility of evidence depends on relevance and competence. Sabi natin kanina, di ba, yung formula, relevancy and competency equals admissibility. Now, weight of evidence naman pertains to the evidence already admitted and its tendency to convince and persuade. So, there are different concept, admissibility and weight of evidence. Admissibility refers to the question of whether certain pieces of evidence are to be considered at all, while weight of evidence or probative value refers to the question of whether the admitted evidence prove an issue. Thus, a particular item of evidence may be admissible, but its evidentiary weight depends on the judicial evaluation within the guidelines provided by the rules on evidence. It's the ruling of the Supreme Court in Ribac versus Ribac-Putolan. Alright? Now, kinds of admissibility, daanan natin ng konti, iba't ibang klase ng admissibility. So, admissibility of evidence, we already know the admissibility of evidence, so there are different kinds of admissibility. Multiple admissibility, evidence which is admissible for two or more purposes. So, of course, whenever you make an offer, whenever you use an evidence, it may be used for two or more purposes. And the court may admit the same, applying the concept of multiple admissibility. Under the rule of multiple admissibility of evidence, even if an accused confession may not be competent as against his co-accused, being hearsay as to the latter, or to prove conspiracy between them without the conspiracy being established by other evidence, the confession is nevertheless admissible as evidence of the declarant's own guilt. So, pwede siyang hindi i-admit sa ibang pagkakataon but in another purpose, or pwede rin siyang i-admit for two purposes. So, multiple admissibility. It must be remembered that the purpose for which evidence is offered must be specified, because such evidence may be admissible for several purposes under the doctrine of multiple admissibility, or may be admissible for one purpose and not for another. Otherwise, the adverse party cannot interpose the proper objection. Another kind of admissibility would be conditional admissibility. Sometimes, the relevance of an evidence is not apparent at the time it is offered, but the relevance of which may be seen when connected to other pieces of evidence not yet offered, in which case the evidence may be admitted conditionally. Later, we'll be discussing the procedure and how an evidence will be offered and how the court will rule as regards admissibility or of offered evidence. So, illustration of conditional admissibility. The plaintiff filed a case for recovery of possession of real property from the defendant. During the case, the plaintiff provided evidence that the property is registered under the name of X. When the defendant raised an objection citing relevancy, the plaintiff clarified that the significance of the evidence would become apparent later when demonstrating that X sold the land to be establishing plaintiff's ownership of the property in question. All right, so that's the doctrine of conditional admissibility. Another illustration on conditional admissibility: in a criminal action, the prosecution witness testified that he saw the person who stabbed the victim to be sporting a color red hair, but the witness was not able to identify the accused in open court. The counsel for the defense moved for the striking out of his testimony for being immaterial. The prosecution countered that it will present evidence that the person whom the witness identified to be sporting a color red hair is the accused. The third kind of admissibility is curative admissibility. It allows a party to introduce otherwise inadmissible evidence to answer the opposing party's previous introduction of inadmissible evidence. So, curative admissibility. A party who first introduces either irrelevant or incompetent evidence into the trial cannot complain of subsequent admission of similar evidence from the adverse party relating to the same subject matter. Here in this doctrine, the parties allowed to introduce an otherwise inadmissible evidence to answer the inadmissible evidence presented by the other party, previous presentation by the party. Illustration: in a collection suit filed by A against B, A introduced evidence that B borrowed money from C, D, and E but did not pay. B objects on the ground that it is immaterial and constitute character assassination. Nevertheless, the court allowed that evidence. B now can introduce evidence that he already paid his debt to C, D, and E. So this is the application of the doctrine of curative admissibility. Classification of evidence: it may be direct or circumstantial. Of course, if it's direct, it proves a fact without the need to make an inference from another fact. Direct evidence. Circumstantial, of course, not necessarily opposite of direct evidence, but the evidence which indirectly proves a fact in issue through an inference with the fact finder draws from the evidence established. Circumstantial evidence. Series of circumstances, like here in People versus Lignes, direct evidence is not the only matrix wherefrom a trial court may draw its conclusion. It is settled that circumstantial evidence is sufficient to support a conviction, and direct evidence is not always necessary. So, what's the ruling of the Supreme Court? The direct evidence does not necessarily mean that the guilt of the accused cannot be proved by evidence other than direct evidence. Direct evidence is not the sole means of establishing guilt. That the crime charge may also be proven by circumstantial evidence, sometimes referred to as indirect or presumptive evidence. No, these are the elements, no, situation where a circumstantial evidence may be used under Rule 133, Section 4. Ito, tinatanong din, pwede ito itanong sa bar, no? Circumstantial evidence. There's more than one circumstance. The facts from which inference are derived are proven, and the combination of all the circumstances is such as to produce conviction beyond reasonable doubt. As explained a while ago, hindi kailangan lahat direct evidence, so pwedeng circumstantial evidence. And of course, not because may circumstantial evidence, it will lead to the conviction. The rules provided for the requirements for the appreciation of a circumstantial evidence. So, more than one circumstance. Let's say, for example, for the crime of murder, no eyewitness, walang nakakita kung paano pinatay si victim. So, what will be the remedy of the prosecution? How can the victims seek justice, no? So, if there's no direct evidence, circumstantial evidence may be used. So, what are the examples or the situation that will show circumstantial evidence? So, in the case of murder, halimbawa, yung knife. Nakita yung knife na malapit sa biktima. So, one circumstantial evidence na nakabalot sa t-shirt ni victim. So, that's one. Number two, nakita yung slippers ni accused, ng tao. So, yung t-shirt ni accused, nababalutan ng knife, tapos yung slippers ni accused, nandun din sa area. Tapos, siguro that's the second circumstance. Siguro mga 5 meters, nandoon yung tricycle na pinagmamayari nung akusado. So, hindi lang siya one circumstance. Kailangan, ang sabi ng rules, there must be more than one circumstance. And the facts from which the inference are derived are proven. And if you combine these circumstances, you will lead to that conclusion that indeed that person is the one who killed the victim. Another clear circumstantial evidence in the given example would be if a witness another witness saw the accused together with the victim few hours prior to the happening of the incident. So, parang hindi siya direct evidence sa makakapagpatunay na siya nga yung pumatay doon sa victim, but it is an circumstantial evidence showing or an inference that if taken all together will prove that that person or that the accused is guilty for the crime as charged. Now, here in People versus Rabaw, no, as mentioned, if there's no direct evidence, circumstantial evidence may be established or may be used. In Lozano versus People, the Supreme Court held that circumstantial evidence must constitute an unbroken chain, which leads one to a fair and reasonable conclusion pointing to the accused to the exclusion of the others as a guilty person. Now, of course, not because nobody saw the commission of the crime, wala nang chance yung mga victims, wala nang chance yung private complainants to get justice or to prove the case. So the Supreme Court said there's still circumstantial evidence, but of course, it must be more than one inference, more than one circumstance, so that if it is collected or if it's connected, all of the circumstances will be connected, then it will lead to the pointing, to the conclusion that it was the accused who committed the crime. So here, example in this case, ito yung mga circumstances na present dito sa case ni People versus Rabaw. Roy saw Jomar walking suspiciously toward the interior part of the neighborhood. Number 2, Roy saw Jomar on the top of concrete fence. Number 3, Jomar jumped off from the fence when confronted by Roy. After Jomar was apprehended, a fire broke out at Dory's house. 5, Jomar was the last person seen at the back portion of the house. Jomar admitted to Roy and Jose that he set the house on fire out of hatred towards Doris. And Fire Officer Gabuya found a matchbox with matches at the back portion of the house. And Gabuya concluded in her report that the burning of the house was intentional. So nakita niyo yung circumstances, hindi lang siya 2 or 3, madami. Kasi kailangan yung inference, yung circumstances present, it will lead to a conclusion that it was really the accused who committed the crime. Circumstantial evidence is like a rope composed of many strands and cords. One strand might be insufficient, but 5 together may suffice to give it strength. Here, the circumstances and pieces of evidence, when weaved together, culminate a vivid illustration that Jomar indeed set fire to Dory's house to the exclusion of all others. Let's proceed now. Nagets na yung klase ng evidence. We proceed now with Rule 129, Mandatory Judicial Notice. So, I need not to discuss this one by one. This is just a reading part or your reading task, no? Whenever you reach 129. So, kailangan at least 1 or 2 or 3, alam nyo yung mga mandatory judicial notice. And no need for proof, no need for evidence. That's why it's called mandatory. So, here in the case of Social Justice Society versus Atienza, while courts are required to take judicial notice of laws enacted by the Congress, the rule with respect to local ordinances is different. Balikan natin, di ba? Nakalagay sa mandatory yung political constitution, history of the Philippines, laws of the nation, laws of nature. Sabi ng Supreme Court, the rule with respect to local ordinances is different. Ordinances are not included in the enumeration of matters covered by mandatory judicial notice. So meaning there's a need to prove such law or local ordinance. Even where there's a statute that requires a court to take judicial notice of municipal ordinances, a court is not required to take judicial notice of ordinances that are not before it and to which it does not have access. So that's the ruling of the Supreme Court in Social Justice Society. Now, how about discretionary judicial notice? So, a court may take judicial notice of matters which are of public knowledge, capable of unquestionable demonstration, or ought to be known as judges because of their judicial functions. Mandatory, yung isa discretionary. The court may or may not take judicial notice. So, if it's discretionary, hindi required si court na mag-judicial notice and he may ask for evidence. But, under the rules, discretionary nga siya. So, ano yun? Public knowledge, capable of unquestionable demonstration, or ought to be known to judges because of their judicial function. Halimbawa, public knowledge. Sino bang bagong break ngayon na magjowang artista? So, public knowledge, hindi alam ni judge. Magte-take ba siya ng judicial notice? Hindi siya sigurado. So, mag-present kayo ng evidence to prove that breakup. Parang gano'n ng nature ng discretionary judicial notice. Or, pwede rin na updated si judge. Lagi nagti-TikTok, lagi nanonood ng reels. So, pwede yun. Kaya discretionary. As compared with mandatory, kasi required na i-take yun na judicial notice. No need for any evidence to prove that. Alright? So here in the case of Supreme Court in Ofracio versus People, the Supreme Court took judicial notice that the use of tricycles to transport heavy objects such as appliances and furniture is a common practice in the Philippines, particularly in rural areas, as tricycles are readily available in a more affordable way of transporting items, especially for those who cannot afford to rent a truck or jeepney. So, judicial notice sa paggamit ng tricycle. So, sabi ng Supreme Court, judicial notice yan. Okay? Okay. Hypothetical case lang for cases, no? There are 2 civil cases pending between the same parties. One is being heard by Branch 92, and the other one is being heard by Branch 93. Can Branch 92 take judicial notice of the case pending in Branch 93? Suppose the 2 cases are pending in the same branch, which is Branch 92. Can the judge take judicial notice of the other case between the same parties? So, this pertains to 2 different cases. So, Anong sabi ng Supreme Court? Can the judge take judicial notice of the case pending in the same court? So, anong rule? When in the absence of any objection with the knowledge of the opposing party, the contents of the other case are clearly referred to by title and number in a pending action and adopted and read into the records of the other case. And when they are requested to form part of the record of the other case. So that's how the court will take judicial notice of the case pending in the same court. When is hearing necessary? With respect to other matters not falling within the mandatory or discretionary judicial notice, the court can take judicial notice of the following. During the pre-trial and trial, the court, pwedeng motu proprio or upon motion, shall hear the parties on the propriety of taking judicial notice of any matter. So wala dun sa enumeration ng mandatory or discretionary judicial notice. So during the trial and pre-trial, the parties may ask the court to, the parties may move for the hearing as regards the propriety of the taking of the judicial notice. Or before judgment or on appeal, the court may take judicial notice of any matter and shall hear the parties thereon if such matter is decisive of a material issue in the case. In the case of People versus Tundag, the Supreme Court held that judicial notice of the age of the victim is improper, despite the defense counsel's admission according to prosecution's motion, as required by Rule 129, Section 3, as to any other matter such as age. A hearing is required before courts can take judicial notice of such fact. Generally, the age of victim may be proven by birth or baptismal certificate, or in the absence, upon showing that said documents were lost or destroyed, or by other documentary evidence sufficient for that purpose. Here in this case, kasi, there was a issue as regards the age of the victim. And the Supreme Court said that judicial notice of the age of the victim is improper, meaning to say, it must be proven, meaning to say there must be evidence to be submitted to prove the actual age of the victim. After the judicial notice, we proceed now with judicial admission. So judicial admission, the requisites must be made by a party to a case. It must be made in the course of the proceedings in the same case, and it does not require a particular form. So the rules also define the judicial admission that is made. It is made in the course of the proceedings in the same case. So how can you know that it is judicial admission? Any admission, verbal or written, made by a party in the course of the proceedings in the same case. So that's judicial admission. No need for proof. It was done. The admission was done in the proceedings of the same case. So the admission may be contradicted only by showing that it was done through culpable mistake or that no such admission was made. Now, a party who judicially admits a fact cannot later challenge the fact as judicial admissions or a waiver of proof. Judicial admission, how do you know it's judicial admission? Admission done in the proceedings in the same case. So, a judicial admission also removes an admitted fact from the field of controversy. Why? Because there's already an admission, no need for proof. Now, judicial admissions are admissions in the following: in the pleadings, during the trial, either by verbal or written manifestation or stipulation, during the pre-trial or other stages of the judicial proceedings. In the case of Darantino versus Fuentes, the Supreme Court said judicial admissions are legally binding on the party making the admission. Correspondingly, facts alleged in the complaint are deemed admissions of the plaintiff and binding upon him. The allegations, the statements, or admissions contained in a pleading are conclusive as against the pleader, and he cannot take subsequently a position contrary or inconsistent with his filed pleading, judicial admission to. Other judicial admissions in the pre-trial of civil cases, admission during pre-trial in criminal case does not result to judicial admission without complying to the requirement provided under Rule 118. So ano yung requirement? All agreements or admissions made or entered during the pre-trial conference shall be reduced in writing and signed by the accused and counsel. Otherwise, they cannot, this admission, these provisions in the alleged stipulation and agreement in the pre-trial conference in a criminal case cannot be used against the accused. The agreements covering the matters shall be approved by the court. All right, how about the stipulation of facts during trial? It is not required that it be signed by the lawyer and the accused. The stipulation of facts are already contained in the transcript or in the TSN. The lawyer is presumed to have prima facie authority to make relevant admission by pleadings, by oral or written stipulation, which, unless withdrawn, are conclusive. So, stipulations and admission. Admission in an amended pleading. Kung natatandaan ninyo sa discussion, sa pag-aaral ninyo ng SpecPro, di ba may amendment? So, the amended pleading supersedes the old. So, that's the rule on amendment. So, it supersedes the pleading that it amends, and the admission in the superseded pleading may be offered in evidence against the pleader. But the admission will be treated as an extrajudicial admission. So yes, it is still admissible as an extrajudicial admission. Bakit? Kasi nga na-amend na eh. Na-amend yung pleading, yung old pleading, superseded na siya. So, syempre may mga admissions doon, may mga allegations or statements made in that old pleading. So, what will be the treatment? That the contents of the superseded pleading may be treated as an extrajudicial admission. How about admission in a dismissed pleading? It is merely an extrajudicial admission. Admission of a proposed state witness. I don't know if you are done already with criminal procedure, but you're familiar siguro with state witness and there are requirements, no? If an accused wants, one of the co-accused desires to become a state witness, there is a requirement for an execution of a sworn statement. And the sworn statement will contain several admissions. Kasi pagka nag-apply ka as a state witness, no, there's an admission of the guilt, admission of the commission of the crime, but you're the least guilty actually. So it will be stated in the affidavit. So, if you will be applying, if you will be asking the court, filing a motion to be discharged as a state witness, but your motion was denied, what will be the effect? You have the admission in the sworn statement, what will happen now? So, the motion shall, of course, the contents, the sworn statement that was attached to your motion shall be inadmissible in evidence. Again, if the motion is granted, of course, you will benefit from that admission. Kumbaga, gagamitin yon sa motion para mag-grant ang court, para maging state witness ka. Pero pagka ito namang motion mo to be discharged, a state witness is denied, then whatever admission you made will not be used against you and shall be inadmissible in evidence, as specifically provided under Rule 119, Section 17. What is the effect of judicial admission? Parang judicial notice, judicial admission, hindi kailangan ng evidence. No need of proof. It's a waiver of proof and production of evidence is dispensed with. It removes an admitted fact from the field of controversy. And in fact, sabi ng Supreme Court, the rules require that the party who made the admission must show that it was made through palpable mistake or the imputed admission was not in fact made. So if you give statement, admission, verbal or written, in a proceeding that is considered a judicial admission, then it's considered waiver of proof and no longer required to prove such item. So it will be removed nga from the field of controversy. Let's proceed now with the kinds of evidence. Documentary, object or real, and testimonial evidence. So, tatlong klase yan, no? So, documentary evidence consists of writings, recordings, photographs, or any material containing letters, words, sounds, numbers, figures, symbols, or their equivalent. If you're taking the bar, please create your, of course, you're taking the bar now, please create your mnemonics, no, on how to memorize the sequence. Ano-ano yung klase ng documentary evidence, writings, recordings, photographs, or any material containing what? If there's letter, words, sounds, numbers, figures, symbols, these are documentary evidence. And also, photo, including still pictures, drawings, stored images, x-ray films, motion pictures, and videos are documentary evidence. Object evidence naman are those addressed to the senses of the court. When an object is irrelevant to the fact and issue, it may be exhibited to, examined, or viewed by the court. Magkaiba yung documentary and object evidence. Kasi when we say documentary, siguro for your own convenience din siguro, pag document, di ba? Document, numbers, letters, yan, agreements, documentary evidence. Object evidence addressed to the senses of the court. It can be seen, can be felt, you can touch it, you can hear it. So, object evidence, senses. Okay, when object is relevant to the fact and issue, it may be exhibited to as or examined or viewed by the court. Example, I bottled water. This is not a documentary evidence. This is an object evidence. Okay, so the difference from the term itself, di ba, ma-identify nyo din. Alright? So, as mentioned, documentary evidence may pertain to recording, photograph, and sound. And pictures may also include still pictures, drawings, stored images, x-ray films, motion pictures, or videos. They are considered documentary evidence, but also they are classified as electronic evidence. Depende sa nature ng ng purpose, how it is offered. Kasi may requirement kailan mo i-apply yung rules on electronic evidence. Okay? So let's proceed now with the original document rule. The old name for this rule would be best evidence. Best evidence rule. So, pero ngayon, it's called original document rule. So, when is it applicable? When the subject of the inquiry is the contents of a document, writing, recording, photo, or other record. So, ang issue, yung contents ng isang document. Ibig sabihin, if that is the issue, no evidence is admissible other than the original document itself. So, if the subject matter, if the evidence needed, would be the contents of a document, the only evidence that can be presented to prove the contents would be the original document. That is why it's called original document rule. Take note of that. Now, the original document rule applies only when the terms of the writing are in issue. When the evidence sought to be introduced concerns external facts such as existence, execution, or delivery without reference to its terms, best evidence rule cannot be invoked. In such a case, secondary evidence may be admitted even without accounting for the original. How about photos? Diba? Kanina sabi natin, ang photo ay documentary evidence. So how do you prove it? Kailangan ba original? Sabi ng Supreme Court sa Orillo versus People, if you use photo, it must be identified by the photographer as to its production and testified to as to its circumstances under which they were produced. Who are the persons to testify as regards the accuracy of the photo? The photographer, but he is not the lone witness, required. It's not the only witness that can prove the photo. The rules provide that another competent witness, if the photographer or the video taker is no longer available to be presented in court, the correctness of the photo as a faithful representation can be proved by the testimony of the person who made it or by other competent witnesses that will testify as to the accuracy of the photo. Whenever I conduct lecture on electronic evidence, yung paano mo ipoprove yung picture, ang requirement nga para ma-prove yung accuracy niya, yung photographer mismo. Paano po pagka wala na yung photographer? You present another witness, a competent one. Ibig sabihin, competent witness, competent siya kasi he can testify as to the accuracy of the photo. So, sino yung competent witness? Pwedeng siya yung nag-print kasi nakita niya kung paano dinala sa kanya yung picture, or pwede rin tao na nasa picture. Diba? Halimbawa, group siya, merong tao, may group picture siya, tapos wala na yung photographer, hindi mo ngayon mapatunayan yung accuracy niya. So you can ask anyone present in the photo to prove the accuracy of the photograph. Photographs, therefore, can be identified by the photographer or by any other competent witnesses who can testify to its exactness and accuracy. Original document. What is an original? So the new rules define original document. It pertains to the document itself or any counterpart intended to have the same effect by a person executing or issuing it. An original of the photo includes the negative or any print therefrom. If data stored in a computer, similar device, any printout or output readable by sight or other means that will reflect the data accurately, and they are considered original. And as mentioned, counterpart din siya, ang counterpart ay considered original. So a duplicate is a counterpart produced by the same impression as the original or from the same matrix or by means of photography including enlargement and miniatures, or by mechanical or electronic re-recording, or by chemical reproduction. A duplicate, which is considered a counterpart, is admissible unless there's a genuine question as to the authenticity of the original, or it is unjust or inequitable to admit the duplicate in lieu of the original. So, admissible as original document and duplicate or counterpart. So, take note of that. Exceptions to the original document rule. This pertains to the secondary evidence. As a rule, if the subject matter would be writings, agreements, etc., you have to use the original document itself. But what if the original document is no longer available? No duplicate also, no counterpart also. So what would be the remedy? You use secondary evidence. When will you use secondary evidence? When the original is lost, destroyed, or cannot be produced in court without bad faith on the part of the offeror. When the original is in the custody or under the control of the party against whom the evidence is offered, or the original cannot be obtained by local judicial processes or procedures. What else? When the original consists of numerous accounts of other documents and cannot be examined in court without great loss of time, and the fact sought to be established from them is only the general result. So, this would be summaries, no? Masyadong madaming documents. Hindi mo na kailangan dalhin lahat ng original, voluminous na. Summary na lang pwede. Pwede mong dalhin as secondary evidence. When the original is a public record in the custody of a public officer, and the original is not closely related to a controlling issue. So, secondary evidence. So, what are the instances when the original of the document may not be presented? The first exception would be when the original document is lost, destroyed, or cannot be produced in court. So, secondary evidence. How do you present secondary evidence? Number one, the offerer must prove its due existence and execution. The offerer must prove its unavailability, and the offerer must prove that its unavailability was without bad faith on the part of the offerer. So if you will be using secondary evidence, you are the proponent, no, you are the party, litigant who will be using secondary evidence. There should be no error on your part or bad faith on your part kasi you can only use secondary evidence if the original document is lost. Pero kung ikaw yung source ng reason, ba't siya nawala? Medyo hindi ka compliant doon sa requirement because there should be absence of bad faith here. Kasi you're using a secondary evidence and you're claiming that it was lost without your fault. So, kailangan wala ka talagang fault. Okay, how do you prove it? How do you use secondary evidence? By a copy, recital of the content, and by the testimony of the witnesses in the order stated. How do you present secondary evidence if the original is in the possession of the adverse party? So you must prove the existence. You must also prove that the document is in the control of the adverse party and the proponent had given the chance, no, the other party to produce the document and the other party failed to produce the original document. So you can proceed with the presentation of the secondary evidence when the original documents are in adverse parties' control. So how do you do it? By a copy or recital or the testimony of the witness and the order stated. Paano naman kapag numerous accounts? Sobrang dami, hindi mo ma-present. Hindi mo na kailangan i-present lahat ng original. So pwedeng summary. The offeror must show that the documents are voluminous, that they cannot be examined in court without great loss of time, and the fact sought to be established from them is only the general result. What is the secondary evidence when the original documents are voluminous? And what do you call them? It's in the form of a chart, summary, or calculation. But take note, whenever you use summary or this kind of secondary evidence, the original evidence must always be available when required by the court. When the parties required to examine this document. Siyempre, hindi ka mag-iimbento ng storya na sobrang dami ay mag-ano na lang tayo summary. So, kailangan may source. Kailangan may yung chart na yon anytime available, i-check yung source ng chart na yon or ng summary na yon. So, yon ang secondary evidence. So, please take note that the originals shall be available for examination or copying or both by the adverse party at a reasonable time. So, ito yung pinapaliwanag ko kanina na kailangan available siya when needed for examination. So, here in the case of Republic versus Mubas, the Supreme Court agreed with Piatco that it did not submit numerous and voluminous invoices, official receipts, and other relevant documents before the trial court to prove the attendant costs that it incurred. The trial court may admit a summary of voluminous original documents in lieu of the original document if the party has shown that the underlying writings are numerous and that an in-court examination of these documents would be inconvenient. But as a condition precedent to the admission, the proponent must lay a proper foundation for the admission of the original documents on which the summary is based. So that's the secondary evidence of summary. In concrete terms, the source documents must be shown to be original and not secondary also. Of course, the summary itself is secondary evidence. It should be original kasi yun nga yung source ng iyong summary. And you ask the court for the presentation of this summary. So, how do you present secondary evidence when the original is in the custody of a public officer? When the original is in the custody of a public officer or is recorded in a public office, its contents may be proved by a certified copy issued by the public officer. So, in custody. So, certified copy that it is there in their office. They cannot bring the original to court, so you ask for a certified copy of the document. So, in Henyo versus People, the marriage certificate is a prima facie evidence of the contents is allowed under the rules. Public records appearing in the civil register, including the marriage certificate, are prima facie evidence of the facts therein stated as provided in the rules. So under the provisions of the law, the entries found in public records are presumed correct unless the party who contests their accuracy produce positive evidence establishing otherwise. So public records. And also, in the same case of Henyo versus People, the trustworthiness of public documents and the probative value given to the entries made are founded on the sense of official duty in the preparation of the statement made, the penalty of which is affixed to the breach of the duty and to the routine and disinterested origin of most statements, rather, and the publicity of the records. So, which makes more likely the prior exposure of such errors as might have occurred. The Supreme Court said that a marriage certificate as a public record is the primary evidence of a marital union and the best evidence of its contents. So, we're done with secondary evidence. Let's proceed now with parole evidence. Parole evidence, when are you going to apply parole evidence rule? When the terms of an agreement have been reduced to writing, it is considered as containing all the terms agreed upon and as between the parties and the successors and interests, and no evidence of such other terms can be used or can prove the agreement of the parties aside from that document. That's parole evidence. So what are the exceptions of this rule? So when are you going to apply parole evidence, written contract, parties and the successor in interest, and it may be applied to a will. So what are the exceptions to the parole evidence rule? So these are the instances when a document may be modified, may be corrected, may be changed. So if there is an intrinsic ambiguity, mistake, or imperfection in the written agreement, the agreement failed to express the true intent and agreement of the parties. It may also be changed if there's an issue as regards the validity of the written agreement and the existence of other terms agreed to by the parties after the execution can be a ground for the as an exception to the parole evidence rule. Now, please take note that the party must put them as issue in a verified pleading. Before we proceed with this kind of evidence, please take note that you will only use parole evidence rule. You will only apply that if there is ambiguity in an agreement. So there must be a document. There must be an agreement. The rules provide that if there's an agreement, all the terms, all the conditions agreed by the parties are stated there in the agreement. It cannot be changed because it's already been signed. It has already been executed by the parties. Now, if there are, as mentioned, if there are ambiguities, there's imperfection, there's question as regards to validity, then there can be, the parties can be allowed to modify or explain or add something to the terms of the agreement, as long as one of these exceptions are present. Take note of the exceptions to the parole evidence rule. Testimonial evidence, it consists of the statement of a witness offered to court, maybe oral or written. So, testimonial evidence, because of the provisions of the judicial affidavit rule, the party may execute prior to the presentation as required also at the initiatory pleading. The party may be required to submit, or the parties are required rather to submit judicial affidavit, and the same will be considered as the direct testimony of the witness. So that's why testimonial evidence may be oral or written. Judicial affidavit or by deposition. At the time of the witness, at the time the witness is called, then the offer will be made, and the offer is made orally. The judicial affidavit contains the testimony of the witness. It also contains the offer as regards the purpose of the said testimony. Who is qualified to become a witness? So all persons, take note, the rules provide that all persons who can perceiving or can make known their perception to others may be witnesses. Under the rules, all. As long as you can perceive, actually perceiving, and can make known your perception to others may become witnesses. Regardless of your belief, conviction, unless otherwise provided by the rules na bawal ka mag-testify, it shall not be a ground for disqualification as a witness. Take note, even convicted criminals are not excluded from testifying in court so long as having organs of sense, they can perceive and perceiving and can make known their perception. Of course, except the conviction for falsification of a document, perjury, or false testimony. Disqualified sila, to become a witness to a will. An accused who has been convicted of any offense involving moral turpitude and cannot be discharged to become witness for the government. So again, all persons perceiving, can perceive and can make known of their perception can become witnesses. An intellectually disabled person is not solely by this reason ineligible from testifying in court. He or she can be a witness depending on his or her ability to relate what he or she knows. If an intellectually disabled victim's testimony is coherent, it is admissible in court. So nakita niyo yung requirements ng rules, Pwede maging testigo kahit intellectually disabled as long as he can make known of his perception, he can testify, and coherent yung kanyang testimony, then he's qualified to become a witness. A person with a low intelligence quotient may still perceive and is capable of making known his or her perception to others. Let's proceed now with disqualification. Disqualification to become witness. Kasi sabi, di ba sa rules, all persons can become witness, pero may disqualification. Meron mga disqualified. Pero specific situation or specific cases. Disqualification by reason of marriage. During their marriage, the husband or the wife cannot testify against the other without the consent of the affected spouse. If you are married, during your marriage, you cannot testify against the other. Okay? Hindi kayo pwedeng magtestigo laban sa isa't isa except, at take note pala, mayroon nakalagay without the consent. So, pag pinayagan mo, pwedeng mag-testify laban sa'yo. So, the rule, you're disqualified from testifying against your spouse without the consent, except in civil case by one against the other, or in a criminal case for a crime committed by one against the other, or the latter's direct descendants or ascendants. Now, yun, so exception nga, in a civil case by one against the other, or in a criminal case for a crime committed by one against the other, or the latter's direct ascendants or descendants. In the case of Sanchez versus Daroca, here the petitioner admits to being separated in fact from Labinghisa for more than a decade. Yet, this does not suffice as an exception, as separation is not tantamount to strained marital relations. Sabi kasi ng rules during the marriage. So, even though you're separated, you're not living together, doesn't mean the marriage is already dissolved. Okay? So, separation is not tantamount to strained marital relation. Further, neither spouse committed an offense that impaired their conjugal union. Okay? So, take note of the disqualification of spouse, so disqualification during marriage. A spouse may testify in a trial where the other spouse is a co-accused against the other accused other than her husband. The testimony cannot, however, be used against the accused appellant here, the husband, directly or through the guise of taking judicial notice without violating the marital disqualification rule. So here is the case kasi, for murder committed by group of people, and one of the accused is her husband, and the eyewitness testified against the other accused or co-conspirators. But the said testimony cannot be used against the husband because it's a violation of the marital disqualification rule. But so first, the other accused, the wife may testify against the other accused, even though her husband is a co-accused. Okay, that's what the Supreme Court said in People versus Kidato. Let's proceed now with privilege communication. Disqualification by reason of privilege communication. Yung kanina, yung disqualification, marital disqualification rule. Ito naman, disqualification by reason of privilege communication. Number one, husband or the wife. Ang rule dito, during or after marriage, either husband or wife cannot be examined, meaning they cannot be witnesses without the consent of the other as to any communication received in confidence by one from the other during the marriage, except in a civil case filed by one against the other, or criminal case for a crime committed by one against the other, or the direct ascendants or descendants. So, privilege communication, husband and wife, during or after the marriage. You cannot be examined. Alright? Ano yung subject matter? Paano kapag ang subject matter ng testimony ay yung pagbentahan ng lupa, halimbawa, ite-testify ni wife, halimbawa. So, yun ba ay subject matter ng privilege communication? It depends. You have to identify what kind of communication was that, because the rules provide that the communication must receive in confidence by one from the other. That's why it's called privilege communication. You cannot testify. You are disqualified to testify for any communication received in confidence. Okay, you cannot be examined. And take note, ang difference kasi ng marital disqualification rule sa privilege communication, yung marital disqualification, you are disqualified from testifying against your spouse. In privilege communication, the subject matter of your testimony is as regards a communication you receive. You're not testifying against your wife or against your husband. The privilege communication is the subject matter of the testimony. So if you receive a communication during the marriage, you are prohibited from testifying as regards a communication you receive from your spouse, and the prohibition could be valid or applicable during or after marriage. So kahit na kayo ay hiwalay na kahit kayo ay yung inyong marriage ay dissolved na or annulled na, or meron ng ruling ang court as regards your marriage, the privilege communication, the disqualification by reason of marriage is still applicable. Alright? Sige. Next one would be the attorney and client, no? Disqualification by reason of privilege communication. Ito yung requirements sa disqualification by reason of communication. Who are persons involved here? An attorney, person reasonably believed by the client to be licensed to engage in the practice of law, attorney secretary, stenographer, clerk, or other persons assisting the attorney. So they cannot be examined. And what are the matters covered by the privilege? Any communication made by the client, advice given, any fact, the knowledge of which has been acquired in such capacity. Take note, privilege to. Privilege communication, attorney and client. And hindi lang si attorney ang involved dito. Person reasonably believed by the client to be an attorney, kasama din ang secretary, stenographer, clerk, or any other persons assisting the attorney. So these are the persons covered by this disqualification as regards attorney and client relationship. So what are the exceptions to the privilege? Furtherance of crime or fraud. If the services or advice of the lawyer were sought to or obtained to enable or aid anyone to commit or plan to commit what the client knew or reasonably should have known to be a crime or fraud. So meaning to say, if there's furtherance of crime, if there's fraud, then pwedeng mag-testify. Pwedeng exempt no, sa privilege communication ng attorney-client kasi may fraud or crime na involved. Claimants to the same deceased clients. Any communication relevant to the issue between parties who are claiming no, from the same deceased client, pwedeng mag-testify. Next, breach of duty by a lawyer or client. So, exception to the privilege communication. And any document attested by the lawyer. So, as to communication relevant to an issue concerning an attested document to which a lawyer is an attesting witness, then it is an exception to this privilege communication of attorney-client relationship. Yeah, so joint clients also. So, exception to the privilege. Third kind of privilege communication would be physician, psychotherapist, and patient. So, who are the persons involved? The physician, psychotherapist, or person reasonably believed by the patient to be authorized to practice medicine or psychotherapy cannot, in a civil case, without the consent of the patient, be examined as to any confidential communication made for the purpose of diagnosis or treatment of the patient's physical, mental, emotional, including alcohol or drug addiction between the patient or the physician or psychotherapist. So, sino yung subject matter dito? Yung doktor, yung psychotherapist. They are not allowed to testify in a civil case insofar as the communication or any confidential communication made for the purpose of diagnosis. Okay? But pwede, exception? Pag magko-consent. Pag magko-consent yung patient. And the privilege applies to the members of the patient's family who have participated in the diagnosis or treatment of the patient under the direction of the physician or psychotherapist. In the case of Chan versus Chan, to allow, however, the disclosure during discovery procedure of the hospital records, the results of the tests that the physician ordered, the diagnosis would be to allow access to evidence that is inadmissible without the patient's consent. So, ano ibig sabihin, Judge? Pwede palang ma-present yan, pwedeng gamitin, pwede, basta mag-consent yung patient. So, physician memorializes all this information in the patient's records. Disclosing them would be equivalent of compelling the physician to testify on privileged matters he gained while dealing with the patient without the latter's prior consent. So, okay, pwedeng mag-testify subject to the approval and consent of the patient. Number 4, priest and penitent. Mali yung spelling ko. Mali yung spelling sa screen. Dapat petinent to. Petinent nakalagay, dapat penitent. Okay. A minister, priest, or person reasonably believed to be so cannot, without the consent of the affected person, be examined as to any communication or confession made or advice given by him or her in his or her professional character in the course of discipline enjoined by the church to which the minister or priest belong. Hindi pwedeng na-examine si father, si minister, si pastor, kung sino man na nakausap or nagbigay ng advice in relation to this professional character. So, cannot be examined under the rules on disqualification by reason of privileged communication. Public officer, number 5. Public officer cannot be examined during or after his or her tenure as to communications made to him or her in official confidence. But of course, when the court finds that the public interest would suffer by the disclosure, hindi pwedeng ma-examine sila for that purpose. So, part of the privilege communication. Take note, before we take our break, take note, in all instances of disqualification, by reason of privileged communication shall remain privileged even in the hands of a third person who have obtained the information, provided that the original parties to the communication took reasonable precaution to protect its confidentiality. So it shall remain privileged even a third person was able to get that information. So it will remain privileged. And with that, let's have our short break.
Why Central Books?
Because it's the home of the best legal minds. Central Books has always been a good friend.
Shows that because it's the best bookstore here in the Philippines. No one else.
Of course, the Central Books na magandang policy.
With so many authors, with so many books that are being printed day in and day out. It has, I think, the state-of-the-art machines that can really, transform all of these books very fast.
So I want to be part of that home of the best legal minds.
Central has been very accommodating, very flexible in terms of discussing with the arrangements and all throughout the process. So
That is the reason why it is really privileged to become the author of this Central Books.
Central Books was able to establish a name in getting authors who are basically experts on their fields.
Well, they share the same passion as me, and they believe likewise in providing accessible quality education to the examinees, students and examinees, and they have produced so many authors.
Central Books is always ahead, up to date, hands-on, and very accessible to the authors.
Hands-on kayo. And you reach out to the lawyers, to the authors, and yung encouragement and yung support, nandun talaga yung support.
Central Books really gave us the platform and opportunity to help the law students to bring out the materials for them, and they encourage nila yung authors nila to create books for the students. So that's why I think Central Books is a great avenue for law practitioners, for lawyers, for judges to share knowledge to law students, even to members of the bar.
It's just CBSI #1.
Let's proceed now with testimonial privilege. So, marital disqualification rule, privilege communication, disqualification by reason of privilege communication. How about testimonial privilege naman? Okay, so iba naman din tong storya na to. Filial and parental privilege. So, parental privilege, a parent cannot be compelled to testify against his child or direct descendants. On the other hand, the filial privilege, the child may not be compelled to testify against his parent or direct ascendants. Take note, this pertains to compulsion. This is not prohibition or disqualification to testify against the child or against the parent. It's a compulsion. Cannot be compelled to testify. So that's the nature of parental and filial privilege. Now, the rule applies only to direct ascendants and descendants, a family tie connected by common ancestry. Hence, a stepdaughter has no common ancestry by her stepmother. In the case of Lee versus Lee, promulgated by the Supreme Court in 2022. How about privilege relating to trade secrets? So, a person cannot be compelled to testify about any trade secret unless the non-disclosure will conceal fraud or otherwise work injustice. When the disclosure is directed, the court shall take such protective measure as to the interest of the owner of the trade secret and of the parties and the furtherance of justice may require. So, alam mo yung formula ng KFC, di ba? Yung formula ng masarap ng KFC or ng Max Fried Chicken, halimbawa. So, yung mga transaction, yung paano minamanage yung business, you have the personal knowledge, and you cannot be compelled to testify. So, take note, the prohibition is the compulsion, not disqualified to testify. Take note, cannot be compelled. If you don't want to testify, then you cannot be compelled unless the non-disclosure will conceal fraud or otherwise work injustice. And of course, if you will be directed to testify, the court will make sure that the interests of the owner of the trade secret will be protected. Alright, let's proceed now with admission and confession. Yung kaninang diniscuss natin, no, yung judicial admission, iba yun, doesn't need proof. Ito naman, admissions made and confessions made by the accused. So, ano yung ruling as regards admission? Admission under Rule 130 pertains to act, declaration, or omission of a party as to a relevant fact may be given in evidence against him or her. An admission may pertain to an act, declaration, or omission. Alright? So, not necessarily positive action lang. Maybe an act, declaration, or omission. Now, please take note that the act, declaration, or omission must be presented as evidence against the party making the act, declaration, or omission. It should not be in favor of the party making the act, declaration, or omission because it will become self-serving. So your admission, your declaration, your omission will be presented against you who made the admission, declaration, or omission, not in your favor because it will be self-serving. In civil cases, offer of compromise. In civil cases, an offer of compromise is not an admission of any liability and is not admissible in evidence against the offerer. It's an offer of compromise. If you offer, it is not an admission of any liability. Neither is evidence of conduct nor statements made in compromise negotiation admissible, except evidence otherwise discovered or offered for another purpose, such as proving bias or prejudice of a witness, or proving effort to obstruct a criminal investigation or prosecution. So if there's offer not considered an admission of any liability. It is clear in civil cases, offer of compromise is not an admission of liability. Also, evidence of conduct or statements during the compromise negotiation. So, there are times kasi when parties discuss matters, discuss negotiation, they negotiate on the settlement, maraming lumalabas dyan na behavior, maraming nangyayaring pag-aamin, basta maraming lumalabas during the negotiation. And the rules provide that any evidence of conduct or statements made during the compromise negotiation are inadmissible. Alright? So, can the statements or conducts made during the compromise negotiation be admissible? As mentioned kanina, as a rule, no, but in some instances lang, except in this instances, evidence of conduct or statements discovered other than during the negotiation, if the offer is to prove bias or prejudice, to negate a contention of delay, and to prove an effort to obstruct a criminal investigation or prosecution. So as a general rule, hindi. But these are the exceptions provided in Rule 130. And of course, as emphasized by the Supreme Court, it always favor compromise agreement. Gusto niya na instead of full-blown trial, instead of maghihiring, magkakasakitan pa sa mga testimony, pwede namang mag-compromise. So, the law favors compromise agreement. But offers for compromise are irrelevant. So, they are not considered an admission of liability because they are not intended as admissions by the parties making them. A true offer of compromise in legal contemplation involve an admission on the part of the defendant that he or she is legally liable, or on the part of the plaintiff that his claim is groundless or even doubtful, since it's made with a view to avoid controversy and save the expense of litigation. That is why the rules emphasize offer, no? The offer of compromise is not an admission of any liability. Kasi ganun talaga, no? Pag nag-discuss yung mga tao sa civil cases, sa PMC, sa mediation, or sa JDR, maraming pwedeng lumabas. Kaya kailangan clear yung understanding nyo sa offer of compromise. In criminal cases, iba. Okay, so except in criminal negligence, an offer of compromise by the accused may be received in evidence as an implied admission of guilt. So if you will be asked in the bar exam, so what's the difference between the effect of an offer of compromise in civil action or criminal action? Please take note of the difference. Because in civil action, no liability offer. But in criminal cases, ang offer ay implied admission of guilt. Now, however, an offer to pay or the payment of medical, hospital, or other expenses occasioned by an injury is not admissible in evidence as proof of civil or criminal liability for the injury. In the case of People versus Urquiza, an offer of compromise from an authorized person cannot amount to an admission of a party himself. Highlight lang natin, yung offer of compromise sa criminal action, implied admission of guilt. But there is a ruling dito ng Supreme Court sa People versus Urquiza, pagkagaling yung offer of compromise sa an authorized person, hindi siya inauthorize ng accused to enter into or to give an offer for compromise, hindi siya involved sa case, hindi siya considered as an admission of the party himself. Although the Supreme Court said here, although the court has held in some cases that an attempt of parents of the accused to settle the case is an implied admission of guilt, the better rule is that for a compromise to amount to an implied admission of guilt, the accused should have been present or at least authorized the proposed compromise. Moreover, if it has been held where accused was not present at the time the offer for monetary consideration was made, such offer would not save the day for the prosecution. So meaning to say, even though it was the parents who made the offer, but without the presence of the accused, without the consent of the accused, such will not be considered as an implied admission of guilt. Plea of guilty during the plea bargaining negotiation. So if you are done with your criminal procedure, you're familiar with plea bargaining, and there are negotiations that can be done in court during the plea bargaining. So a plea of guilty later withdrawn or an unaccepted offer of plea of guilty is not admissible in evidence against the accused who made the plea or offer. So that's a rule in criminal action. Now, admission during the hearing for discharge of accused to become a witness. Kanina, meron tayong discussion on this. So, not admissible. Pag dineny yung motion for discharge as a state witness, whatever admissions made in the sworn statement will not be used against that accused and shall be inadmissible in evidence. Admission made by third party. So, di ba, admission and confession tayo. Res inter alios acta, admissions made by third party. Take note of the definition made. I encountered one bar question, so please, on res inter alios acta, please study the concept of res inter alios acta, and it refers to the rights. The concept of res inter alios acta, the rights of a party cannot be prejudiced by an act, declaration, or omission of another, except as herein provided under the rules. Define natin kanina yung admission. It may be an act, it may be a declaration, it may be omission. So that pertains to an admission. So any admission made by somebody, made by a person, it should not prejudice the rights of another. So insofar as I am concerned, ano man gawin ko na admission or whatever act or declaration, it should not, as a general rule, it should not prejudice the rights of a party. Except admission by a co-partner or agent, admission by co-conspirator, admission by previes, admission by silence, and interlocking confession. It must be noted that judicial admission is not applicable in this topic because res inter alios acta is applicable only to extrajudicial admission, but it does not cover judicial admission because of the fact that the other accused had the opportunity to cross-examine the witness. Alright, so what are the exceptions to res inter alios acta? Admission by a co-partner, co-conspirator, privy, silence, and interlocking confession. So in People versus Surigao, the alleged conspiracy among the accused was not established by separate and independent evidence, nor it was shown that the extrajudicial confession were made while they were engaged in carrying out the conspiracy. Confessions were made after the conspiracy has ended and after the consummation of the crime. These confessions cannot be used against the accused without doing violence against his constitutional violation against constitutional right to be confronted with the witnesses against him and to cross-examine them. So, in nature ng admissions or res inter alios acta, if you make an admission, if you make a declaration or omission, it should not affect the rights of another. But if your admission pertains to the existence of conspiracy, it's against a co-partner or co-conspirator or agent, privy, silence, yan, yon, exceptions yon. Kahit nag-create ka ng admission and it affected the rights, admissible yon. Pwedeng i-consider yun ng court because it's part of the exception to the res inter alios acta rule. The res inter alios acta rule provides that the right of a party cannot be prejudiced by an act, declaration, or omission of another. An extrajudicial confession is binding only upon the confessant and is not admissible against his co-accused. The reason for the rule is that, on a principle of good faith and mutual convenience, a man's own acts are binding upon himself and are evidence against him. So are the conduct and declaration. Yet, it would not only be inconvenient but also manifestly unjust that a man should be bound by the acts of strangers. Yan. So, nakita niyo yung ruling ng Supreme Court na hindi, pag gawa mo yan, you should be bound by your acts, omissions, or declarations. It should not affect the rights of a party. Except nga, available or present yung mga exceptions sa res inter alios acta. Here in the case of People versus Bernardo, aside from Antonio's extrajudicial statements in the Salaysay, there's a glaring dearth of evidence showing the participation of accused appellants in a plan or conspiracy to abduct and kill Major Arcega. As such, Antonio's statement is binding on him alone. It cannot be admitted against his co-accused and considered hearsay against them. Alright, so yun yung mga sa mga highlights ng ruling ng Supreme Court kasi nga yung statements should not affect third persons or the rights except for the exceptions ng admission sa nakalagay sa rules of court. Confession naman, on the other hand, it pertains to the declaration of an accused acknowledging his or her guilt or of the offense charge or any offense necessarily included may be given in evidence against him or her. Confession, declaration, acknowledging guilt. Okay? Siya mismo ang naggawa ng acknowledgement ng guilt niya, confession. Is extrajudicial confession alone enough to convict the accused? Kasi extrajudicial confession nga naman. And you've done that, or you made the confession before a police officer out of court. So rules provide that no, Rule 133 provides that an extrajudicial confession shall not be sufficient ground for conviction unless corroborated by evidence of corpus delicti. The confession must be coupled with corpus delicti. So what will be the effect of extrajudicial confession? So it must be corroborated by evidence of corpus delicti, and when we say corpus delicti, it is the body of the crime. It means the actual commission of the crime, and someone is criminally responsible therefore. So in People versus Boko, the elements of corpus delicti would be proof of occurrence of a certain event and some person's criminal responsibility for the act. So, hindi porket inamin niya na siya yung gumawa. Tapos hindi siya coupled, walang evidence ng corpus delicti as regards to commission of the crime. It is in itself a ground for conviction. Kung wala namang evidence, enough support, or walang showing ng body of the crime that would lead to a conclusion that he was the one who committed the crime, then the extrajudicial confession will not lead to the conviction of the confessant. Corpus delicti, as emphasized in People versus Sota, it means the substance of the crime. It is the fact that a crime has actually been committed, or the actual commission by someone of a particular charge. So if somebody will admit, gives confession as regards the commission of a crime, it must be coupled with the actual commission, corpus delicti, proof of corpus delicti. Kailangan makita, ma-provide ng prosecution yung actual commission by someone of a particular crime charge. So some corpus delicti in certain crimes, prosecution for illegal drugs, the corpus delicti is the drug itself. In theft, the corpus delicti has two elements. Property was lost by the owner and it was stolen or lost by felonious taking. In illegal possession of firearm, the accused lack of license or authority to possess or carry the firearm. In arson, the corpus delicti is satisfied by the proof of the bare occurrence of the fire and the charred remains of a house burned down and it's having been intentionally caused. Corpus delicti. So, yan yung some of the examples of corpus delicti. So, when is extrajudicial confession admissible? In People versus Base, as cited in some cases promulgated by the Supreme Court, extrajudicial confession is admissible in evidence if the following requisites have been satisfied. Number one, it must be voluntary, made with the assistance of a competent and independent counsel. It must be expressed and it must be in writing. These are the requisites. Absence of one will make it inadmissible extrajudicial confession, and it will make the confession questionable. So, kailangan complete yung mga requisites na yan. Let's proceed now with hearsay rule. In the new rules, medyo mahaba yung definition ng hearsay. But some of the provisions in the new rules and evidence, or in the cases decided by the Supreme Court, hearsay pertains to an out-of-court statement made by a person who is not presented as a witness, and which statement is offered to prove the truth of the fact asserted therein. Hearsay is a statement other than the one made by the declarant while testifying at a trial or hearing, offered to prove the truth of the facts asserted therein. So for you, please, medyo mahaba yung definition ng rules and evidence sa hearsay. So I will leave the definition with you to please familiarize, kasi medyo mahaba. But in order for you to imagine hearsay, may testigo, nagte-testify siya sa witness stand, nagde-declare siya ng statement na hindi siya yung author. Sinasabi niya lang, nasabi kasi ni, yun hearsay. Yun yung pinaka-easiest way of understanding hearsay. But the rules provide for longer definitions. I will leave the memorizing of the definition to you kasi nga mahaba siya. But let us read anyway. Hearsay is a statement other than the one made by the declarant while testifying at the trial, offered to prove the truth of the facts asserted therein. Let's say you are testifying as to the fact of robbery. Yan, ikaw yung witness. So, testify mo, kasi sinabi ng anak ko siya yung nagnakaw. Oh, so that's hearsay. Kasi that's a statement of another person and you're testifying as to the statement of your child as regards the truth of the robbery. Yan. So, a statement is an oral or written assertion, non-verbal conduct of a person if it's intended by him or her as an assertion. Hearsay evidence, as a rule, of course, is inadmissible. Of course, you have no personal knowledge. You were not the one who made the statement. Kinuha mo lang dun sa statement ng iba yung tinetestify mo. Eh, di ba nga, ano yung requirement sa witness? You must be able to perceive, actually perceiving and make known of your perception. Eh, wala ka namang nakita. Ba't ikaw ang nagtetestigo at ang ginagawa mong testimonya ay yung statement ng iba. So that's why it's inadmissible. But of course, the rules provide for several, several exceptions. So all out-of-court statements of an in-trial witness is hearsay if it is offered to prove the substance of such testimony or to prove the matters asserted by that statement. So, yung sinabi, kaya nga, para ma-conceptualize mo in your mind yung hearsay, sinabi niya, tinetestify ko. Eh, sabi kasi ni Maria, ninakaw ni Mario yung kanyang cellphone. O, eh, anong essence ng testimony mo? Hearsay yun. Hindi yun pwedeng tanggapin. That's why it is inadmissible. Parang ang nangyari, chinismis sa'yo, tapos binigla mong tinestigo sa korte, nananakaw yung cellphone, sabi ni Maria. Parang gano'n. So, inadmissible. But of course, we have exceptions, and we have a lot. Okay? Siyempre, just to save time, daanan lang natin yung usually na tinatanong, na madalas na itanong, at subject matter ng bar question. So, dying declaration, usually, res gestae, and ano pa ba? Yun yung kasi yung medyo naging part ng mga bar questions. But of course, hindi yung pipiliin ito lang yung madalas na tinatanong. So, wag nyo lang ipipinpoint. You have to be familiar with all the exceptions. Dying declaration, statements of decedents or persons of unsound mind, declaration against interest, or declaration about pedigree, family reputation or tradition, common reputation, part of res gestae, regularly conducted business activity, entries in the official record, commercial list, learned treatises, testimony, the former proceedings, and residual exception. Ito ang pinakasikat dito na exception talaga, dying declaration. Alam mo, siyempre, hindi mo na witness yung pagpatay sa isang tao. So, paano ka pwedeng maging testigo? Okay, ikaw, ang mismong naka-receive ng statement mula sa declarant. Kasi, imagine niyo naglalakad ka sa kalsada, may nakita kang nakahandusay, matulungin ka, ikaw ay pinuntahan mo yung nakahandusay, nabuhay pa. At ang sabi niya, ang sumaksak sa akin ay si Maria. So, yun ay dying declaration. Ibig sabihin, yung subject matter ng testimony, hindi mo nakita. Wala kang personal knowledge kung sinong pumatay sa kanya, pero it was a declaration made by that dying person. That's why it's called dying declaration. And admissible lang siya, of course, kapag ka namatay siya, kasi nga dying declaration niya. And it is considered a valid admission, a valid testimony because merong concept na malapit na siyang mamatay at sasabihin, wala nang panahon, no, para sinungaling pa yung mamamatay, para lang mag-create pa ng issue na mag-invento kung sinong gumawa ng crime sa kanya. So, kaya admissible yung mga ganitong klaseng statements. Dying declaration. Ayun. So, yun yung some illustration ng exception. So, in People versus Maglian, witnesses in general can only testify as to facts derived from their perception. A resort in open court of a dying person's declaration is recognized as an exception to the rule. against hearsay if it is made under the consciousness of an impending death that is subject of the inquiry in the case. It is considered as evidence of the highest order and is entitled to utmost credence since no person aware of impending death would make a careless or false accusation. Yun nga yung, siyempre, alam mo nang mamamatay ka, mag-iimbento ka pa ba kung sino yung pumatay sa'yo or pumatay o gumawa ng crime sa'yo. Hindi pala. Kasi pagpatay ka na, hindi ka nakagawa ng declaration. So at that time, aware ka na, mamatay ka na, whatever statement sa ibigay mo, admissible yon as exception to hearsay evidence. Declaration against interest refers to declaration made by a person deceased or unable to testify against the interest of the declarant. Declarations against interest are those made by a person who is neither a party or privy to the case are secondary evidence and constitute an exception to the hearsay rule. Admissible only when the declarant is unavailable as witness. Supreme Court said, a man's act, conduct, and declaration, whenever made, if voluntary, are admissible against him for the reason that it is fair to presume that they correspond with the truth and it is his fault if they do not. So, there's this declaration against interest, then somebody is testifying for that declaration, then that's an exception to hearsay rule. The Supreme Court also laid down the requisites for the admission in evidence of entries in the course of business naman. Exception then sa hearsay doctrine. The person who made the entries dead, outside the country, or unable to testify. The entries were made at or near the time of the transaction to which they refer. Person who made the entry was in a position to know the facts stated in the entries. The entries were made in the professional capacity and the entries were made in the ordinary or regular course of business. Take note, kaya siya exception sa hearsay kasi nga yung nagtatestify, wala siyang participation, wala siyang contribution sa tinetestify na, hindi siya kasama sa business, hindi siya nag-prepare ng entries, kaya nga kailangan ma-establish to na requisites na to before his statement may be considered as an exception to the hearsay rule. The recent amendments provided for the residual exception. So kapag hindi na siya kasama, di ba, we have a lot of exception. Itong residual exception, last part ito ng enumeration. And this pertains to statement not specifically covered by any of the exceptions. Having equivalent circumstantial guarantees of trustworthiness is admissible if the court determines that the statement is offered as evidence of a material fact. The statement is more probative, on point, and the general purposes of these rules and the interests of justice will be served by admission of the statement into evidence. So the Supreme Court has yet to promulgate decisions or render decisions discussing residual exception. So, ang explanation lang natin sa rules, or even as provided in the rules of evidence, not included sa sa enumeration na exception, pero tinawag siyang residual kasi hearsay siya, pero pwede pa rin siyang magamit sa na-i-offer ang isang material fact and justice will be served. Interest of justice will be served if this kind of statements will be admitted. So, yun yung nature ng residual exception. And what are the substantive requirements for the admissibility of residual exception? Equivalent circumstantial guarantees of trustworthiness. Statement is offered as evidence of material fact, probative, on point, and the general purposes of the rule and interest of justice will be served by the admission of the statement into evidence. So in order for a party to rely on the rule of residual exception, it must advise the opposing party sufficiently in advance of the trial or hearing about the statement and the name and the address of the declarant, in order to allow the party to prepare the response to arguments in support of the proposed admission. Again, this is residual exception. Opinion rule, on the other hand, as a general rule, opinion of a witness is not admissible. So parang hearsay evidence, hearsay testimony, as a general rule, is inadmissible. Same is true with opinion. Opinion rule is not admissible except if it's opinion of an expert witness or the opinion of an ordinary witness. So may details, subject matter ng opinion ng expert and opinion ng ordinary witness. But as a general rule, opinion rule is inadmissible. Kailan admissible ang expert opinion or opinion of an expert? Expert witness is one who belongs to the profession or calling to which the subject matter of the inquiry relates and who possess special knowledge on question on which he proposes to express an opinion. Take note, ang tanong, ang subject matter ay yung kanyang profession. Yung involve yung galing niya. So kapag ka medical, kailangan mo ng doctor. Pag kailangan mo ng technology, you have to present an expert. Halimbawa, subject matter ay libel, cyber libel, pinost sa Facebook, hindi mapatunayan kung pinost ba talaga o nag-appear ba talaga sa Facebook yung post na yon. So, hindi malocate. You can present a witness, an expert witness to prove the site, the URL, or whatever na kailangan i-prove na merong ganong post. So, ang expert pwedeng i-present. But, the subject matter of the testimony would be the issue, no? Hindi ka pwedeng lumihis doon sa kanyang expertise. Kapag hindi related yung kanyang expertise, then doon sa tinetestify niya, then it will be considered as an ordinary opinion, which is inadmissible. Alright? Admissibility of the opinion of ordinary witness naman. Di ba? Hindi nga pwede yung opinion ng tao, pero pwede ang opinion ng ordinary witness if the subject matter is the evidence regarding the identity of a person about whom he or she has adequate knowledge, handwriting, which he has sufficient familiarity, and the mental sanity of a person with whom he or she is sufficiently acquainted. Kung titingnan niyo yung enumeration, kailangan may personal knowledge yung ordinary witness. Kailangan kilala niya yung tao, kilala niya na makakatulong yung kanyang pagkakakilala dun sa tao sa pagtetestify niya, or yung handwriting. Familiar siya, nakalagay sa rules, sufficient familiarity, and mental sanity. Of course, you need the doctor to prove the mental state of a person. But here, pwede siyang kuning testigo as regards mental sanity or observation kasi sufficiently acquainted siya. So, pwede yung kanyang testimony as regards the mental sanity of a person. And pwede rin, the witness may also testify as regards his or her impression of emotion, behavior, condition, or appearance of a person. So, the subject matter, yung kanyang sanity. O ikaw, araw-araw mo siyang nakikita na pakalat-kalat sa kalsada ng walang damit. Halimbawa, ganun. So, nakikita mo siya. So, yung testimony mo na yun, yung knowledge mo na yun, as an ordinary witness, may be considered admissible, provided that the purpose of you being presented would be one of those enumerated under the rules. Alright? Character evidence naman, so, hindi siya admissible din. Okay? Hindi ka pwedeng mag-present ng evidence to prove na masamang tao siya. Okay? As a rule, no? Papatunay mo, hindi, masama talagang tao yan. Kaya pinresent ka. So, hindi, as a rule, no, any evidence pertaining to the trait or character of a person is not admissible for the purpose of proving inconformity therewith on a particular occasion. When is evidence admissible naman? So, kailan siya admissible? Siyempre, may mga exceptions din. The character of the offended party may be proved if it tends to establish in any reasonable degree the probability or improbability of the offense charge. Character evidence, ha? If you want to prove the probability or improbability ng offense, pwede mong i-present character evidence ng offended party, yung private complainant. Number 2, yung character ng accused. Yung pwedeng i-prove yung good moral character pertinent to the moral trait involved in the offense charge. Okay, so if the charge would, the criminal charge against the accused would involve moral traits. Let's say, for example, yung estafa, the fraud, involving fraud, fraudulent action. So the accused may prove his or her good moral character pertinent to that character of defrauding other people. So wala po yan sa experience ko naman loko ng tao. Parang ganun. So you have to prove special circumstance kapag nga yung moral trait ipoprove mo as an element of the offense. So, but the prosecution may not prove his or her bad moral character unless on rebuttal. So, as a rule, hindi pwedeng patunayan ng prosecution na masamang tao yung accused. Hindi. Unless on rebuttal na ipoprove ng accused na mabuting tao siya, yung character niya. So, i-rebut yun ng prosecution. And number 3, evidence of the good character of a witness is not admissible until such character has been impeached. So these are the instances when the person's character or trait are admissible in the court. So in case character or trait is admissible, how do you prove it? In all cases in which evidence of character is admissible, proof may be made by the testimony as to the reputation or by testimony in the form of an opinion. Cross-examination inquiry is allowable only to relevant specific instances of a conduct. In cases in which character or trait of a character is an essential element of a charge, claim or defense, proof may also be of specific instances of a person's conduct. So, kailangan when you're going to use character evidence, you have to prove witnesses that will be testifying in court who are familiar with a particular instance that will show the conduct or the character of that accused or of that private complainant. So, kasi character evidence, somebody has to testify as regards the trait, and there must be specific instance to prove that conduct. Kung nakita niyo, kung nakapanood kayo ng Crash Landing, Chloe, Crash Landing audio, kung natatandaan niyo si Captain Ri? Captain Ri ba yun? Captain Ri. Di ba merong part doon na pinanood yung kanyang mga actions, binubuksan yung pinto, tinutulungan yung matatanda, di ba? Kung nakapanood kayo man lang. Okay, yung tinutulungan basta tumutulong siya yon. Pwede yon na consider na character evidence. Ganun yung concept no na series of conduct. Present mo sa court to show the character, the good moral character of the person involved. Alright? Let's proceed now with the examination of witness. So, ano na tayo? From the disqualification, from the qualification, exception, etc. Dito na tayo, how do you examine a witness? And of course, it is done in open court. Okay, done in open court during trial or hearing. So, testimonial evidence, how do you examine a witness? So, in open court, under oath or affirmation. Unless the witness is incapacitated to speak, or the question calls for different mode of answer, the answer shall be given orally. So, the witness will testify in court and done in open court after he has gone the proper affirmation and has taken, he already gave his consent to the taking of the testimony. Alright, what's the order in the examination of the witness? Direct examination by the proponent, cross-examination by the opponent, redirect examination by the proponent, and cross-examination by the opponent. So, yan lagi yung sequence. Okay, direct, cross, redirect, recross. So, kung sino yung nagpe-present ng witness, siya yung nagdi-direct examination. Kapag sino yung kalaban, yung litigant, or yung adverse party, siya yung nag-cross-examine sa opponent. Redirect to make some clarification as to what has been established or as regards to questions during the cross-examination, the proponent may conduct redirect examination and same re-cross-examination by the opponent. Of course, we have this term called impeachment. How to impeach a witness? You impeach a witness by contradictory evidence, by the evidence that his general reputation for truth, honesty, or integrity is bad, or by evidence that he has made at other times statements inconsistent with his present testimony. Of course, may qualification sa isa witness, diba? Meron tayong requirements sa pagtestigo. Lahat naman pwedeng tumestigo, pero syempre, if you are the one presenting the witness, pwede siyang i-impeach. Ibig sabihin, pwedeng ma-question yung kanyang credibility, kanyang reputation, and that's how you impeach. That's the process of impeaching a witness. You present evidence as regards the general reputation of the witness, and you will prove that there were inconsistent statements made by the said witness. That's impeaching a witness. Okay? So, pwede bang ihiwalay ang mga witness? Pwede ba silang i-exclude? Under Section 15, Rule 132, it allows the judge to exclude a witness motu proprio upon motion, and the grounds for not authorizing the exclusion of a witness who is a natural person duly designated representative of a juridical entity, party to the case, whose presence is essential to the presentation of a party's cause, or a person authorized by the statute to be present at the trial or hearing. But the judge or the court may allow the exclusion of a witness. But take note of the exceptions, no, para hindi siya ma-exclude as a witness. The court is allowed to keep separate the witnesses and prevent them to converse with one another directly or through intermediaries until all shall have been examined. There are times kasi during the hearings, the prosecution or the defense or the plaintiff or the defendant would bring several witnesses. And if it is the turn of the plaintiff to present evidence, and let's say, for example, he brought with him 5 witnesses, and the only one will testify for the day, so the court may order the 4 others to be separated or to go out of the room, or to make sure that they will not converse with one another. Or, pwede rin, if 2 or 3 will be testifying, no, pwedeng mauna yung isa, the court may direct the exclusion of others. Alright? Para lang hindi makapag-practice. Okay, burden and proof of burden of evidence. Burden of proof is the duty of a party to present evidence on the facts in issue necessary to establish the claim or defense by the amount of evidence required by law, and it never shifts. It is the duty to establish the truth of a given proposition or issue by such quantum of evidence as the law demands in the case. The burden of proof never shifts. Please take note of this. I encountered one bar question about burden of proof and burden of evidence, a difference between the two. So take note also the burden of proof in different cases. In civil case, the burden of proof is on the plaintiff to establish his case through preponderance of evidence. Criminal case, the burden of proof to establish the guilt of the accused falls upon the prosecution that has the duty to prove all the essential ingredients of the crime. Burden of evidence, on the other hand, is the duty of the party to present evidence sufficient to establish or rebut a fact and issue, or to establish a prima facie case. Burden of evidence. It may shift from one party to the other in the course of the proceedings. Burden of proof never shifts. Burden of evidence depends on the schedule. Let's say it's the turn of the plaintiff. The burden of evidence will be from one party, and burden of evidence transferred to the defendant once the plaintiff is already presented its case. So the burden of evidence shifts to the defendant, while the burden of proof never shifts. So take note, if the plaintiff was the one who filed an action, or the prosecution was the one who filed an action against the accused, they have the burden to prove the cause of action, using preponderance of evidence, and for criminal cases, the burden of proof to prove the guilt of the accused beyond reasonable doubt. That's burden of proof. Presumptions. You know, under the rules and evidence, sobrang dami ng presumptions. Okay? Especially disputable presumptions. But what is presumption? Presumption is an inference as to the existence of a fact not actually known, arising from its usual connection with another which is known, or a conjecture based on past experience as to what course human affairs ordinarily take. It is either presumption juris or of law, or presumption hominis or of fact. These are not allegations, or they do not, nor do they supply their absence. Presumptions are conclusions. They do not apply when there are no facts or allegations to support them. Hence, presumptions may be either conclusive or disputable presumptions. So, what are the presumptions in civil actions? In civil actions and other proceedings, presumption is imposed upon a party against whom a presumption is directed. The burden of going forward with evidence to rebut or meet the presumption. If the presumptions are inconsistent, weightier presumption shall apply. If consideration of policy are of equal weight, neither presumption applies. In criminal action, it pertains to a presumed fact that establishes guilt and which is an element of the offense charge. Then, the existence of basic fact must be proved beyond reasonable doubt, while the presumed fact follows from the basic fact beyond reasonable doubt. Diba? Dami. Naintindihan nyo? Kaya nyo na yan. Okay. So, ibig sabihin, presumption kasi, either conclusive or disputable. I will leave it to you, no, the conclusive presumption and disputable presumption. So, yung presumptions either conclusive or disputable. Tapos yung conclusive presumptions, hindi yun pwedeng i-prove, hindi na siya kailangang establish once, hindi na siya kailangang i-prove or i-cross-examine kasi conclusive presumption siya. Yung existence ng title and yung estoppel, yan, estoppel in pais. So, conclusive presumption yon. And yung disputable presumption, admissible siya or truth siya until ma-dispute siya or ma-prove otherwise. So, pwedeng i-contradict yung disputable presumption at madami siya. Okay? Let's say, for example, the guilt of the accused, the presumption of innocence. So, that's a disputable presumption. So, that is the presumption until proven otherwise. So, ang presumption sa isang akusado, siya ay inosente. Okay? So, ano yung duty ngayon ng prosecution? To prove otherwise. Kasi ang presumption, inosente siya eh. So, disputable presumption siya. So, we have a complete, I think that's 30 plus, kung di ako nagkakamali sa number. Kasi may mga sub-numbers yun. The numbers ng disputable presumption. So, please, basahin ninyo. At kung kaya, intindihan one by one, you have your reviewers, you read it because it's relevant. It's a relevant portion of the rules and evidence in relation to presumption. Now, in presumptions in civil actions and presumptions sa criminal action, sa bagong rules and evidence, dinifferentiate siya. So, sa civil action, presumption is imposed upon a party against whom a presumption it is directed, the burden of going forward with the evidence. Meaning, in a civil action, there's a presumption, let's say for example, for recovery of possession, na ginamit niya na evidence, siya yung owner, di ba? The carrying, the possession of a title carries with it, your name with it, carries with it a presumption that you are the owner of the property. So, you have the burden. The presumption is first to move forward toward that presumption unless proven otherwise. So, kiniklaim mo na you're the owner, you have the title, that's a presumption, you're the owner. So, subject to the proof or rebuttal of other party or of the adverse party. If the presumptions are inconsistent, meaning to say, merong mga other items that would show that you are not actually the presumed owner. Merong mga documents or whatever evidence, the weighter presumption shall apply. But if magkapantay lang, walang i-apply na presumption. Ibig sabihin, you need to prove it. You don't have to use presumptions. You have to prove that matter that you are presenting in court. Now, in criminal action naman, na medyo confusing yung terms na ginamit sa rules on evidence as regards presumption against the accused in criminal case. Kasi here, the presumption, it pertains to a presumed fact that establishes guilt. So may mga crimes kasi, may elements ang some crimes, let's say for example, ang element ng isang crime, let's say bribery, direct bribery ay yung kanyang official duty or member siya or officer siya ng government. So public officer. So that's an element of an offense. Okay, so presumed fact, pag ikaw ay government officer, no, police officer, then the existence of the basic fact must be proved beyond reasonable doubt. So it is an element of the charge. And it is proven. Kailangan mo i-prove yun beyond reasonable doubt, yung participation mo sa transaction, yung public officer ka, while the presumed fact follows from the basic fact beyond reasonable doubt. So, kailangan mo munang ma-establish yung elements na yon, yung presumed fact na yon, para ma-prove yung guilt of the accused beyond reasonable doubt. Tingnan nyo, no? Sa wording kasi ng evidence, presumed fact that establishes the guilt. So, doon muna tayo. Presumed fact that establishes the guilt. Presumption. Ang presumption, kapag ikaw ay police officer, o public officer rather, yan, meron kang accountability sa ganitong mga crimes. Yan. Kasi automatic yun. Kapag may public officer, may expense. Yeah, yung mga crimes related sa public officer. So, and which is an element of the offense. Ayan. Then, yung existence ng basic fact. Ano yung basic fact na kailangan ditong i-prove dun sa crime na pinag-uusapan natin? Yung kanyang pagiging public officer. Yan. So, the basic fact must be proved beyond reasonable doubt. And because it was proven that you are a public officer, the presumed fact follows from the basic fact. So, nagets nyo, malapit na luminaw. So, yung crime, bribery nga, no? So, establish mo muna yung basic fact as element ng offense. So, in-establish mo. Basic pa lang. Ano yung basic mo na kailangang establish? Ikaw ay public officer na kumuha ng pera. Let's say, yun, tumanggap ng pera. So yun yung basic fact na na-establish mo. Ngayon, na-prove mo na siya, it follows yung presumed fact na dahil public officer ka, liable ka for that particular crime. So yun lang yung connection. So yung basic fact na yun, establish mo muna para mag-follow yung presumed fact that establishes your guilt. Kasi iba ng kaso kapag hindi ka public officer. Iba na yun. Basic fact na yun na kailangan mo establish. So, yun yung presumptions under this rule. Okay, offer an objection. Offer an objection is as provided under the rules. The offer of evidence, the comment or objection, and the court ruling shall be made orally. When is the testimony of the witness offered? The offer of the testimony of a witness in evidence must be made at that time the witness is called to testify. Pagka naman documentary evidence offer shall be made after the presentation of a party's testimonial evidence. Take note of that one-day examination of witness rule. A witness has to be fully examined in 1 day only and shall be strictly adhered, subject to court's discretion during trial whether or not to extend for justifiable reasons. In criminal cases, the offer of evidence and the comment and the court ruling shall be made orally. A party is required to make his oral offer of evidence on the same day after the presentation of his last witness, and the opposing party is required to make comment or objection. Thereafter, there should be ruling. In making the offer, the counsel shall cite the specific page numbers of the court record where the exhibits being offered are found. So the court shall ensure that all exhibits are submitted to it on the day of the offer. So that's offer. Objection naman, it's a formal statement opposing, something that has occurred or is about to occur. And the party objecting must state the basis for the objection. And the objection to offer of evidence must be made orally immediately after the offer is made. The court shall also rule immediately after the objection is made, unless the court desires to take reasonable time to inform itself on the question presented. How about striking of the answer? Of course, there are answers given by the witness. So, what are the grounds for the striking of the answer of the witness? So, should the witness answer the question before the adverse party made and gave the opportunity to voice fully its objection? Question is not objectionable, but the answer is not responsive. The witness testifies without question being posed. Inuunahan si counsel, sumasagot agad. Witness testifies beyond limits set by the court, and when the witness does a narration instead of answering the question. So, the court may also order the striking of the answer which are incompetent, irrelevant, and otherwise improper. Tender of excluded evidence. There are times that the court will not allow the admission of a particular evidence, but the offeror may ask the court the same to be attached or made part of the record, so that he may use it. It will still be part of the record, and some of the parties may use it on appeal, raise it on appeal. If the evidence excluded is oral, the offeror may state for the record the name and other personal circumstances of the witness and the substance of the proposed testimony. Dahil lang sobrang very, very quick lang, rules on electronic evidence. Electronic evidence naman, di ba, na sabi natin na yung kinds of evidence, documentary, testimonial, and object evidence. Meron tayong rules on electronic evidence, and some part of the electronic evidence are considered documentary evidence, such as photo, video, yun, mga documentary evidence. But take note that the rules, the Supreme Court promulgated the rules on electronic evidence if it pertains to any information generated, stored, or transmitted in digital form. So it is also known as digital evidence. So electronic data message, information generated, sent, received, or stored by electronic, optical, or similar means. And you only apply the rules on electronic evidence if the subject matter, your evidence, is an electronic document or electronic data message. And how do you know if it's an electronic document or electronic data message? It has been recorded, received, transmitted, stored, processed, retrieved, or produced electronically. It is also an electronic message, electronic document if it's digitally signed. It refers to an electronic document or electronic data message bearing a digital signature verified by a public key listed in a certificate. So, admissible ba digital evidence? Sabi sa rules, Section 2, Rule 3, paano maging admissible ang electronic document? It complies with the rules on admissibility prescribed by the rules of court and authenticated in a manner prescribed by the rules. Tandaan yung formula, admissibility equals relevance and competence. And may third part, pag electronic evidence, kailangan authenticated in the manner prescribed by the rules. So in the case of Napocor versus Codilla, hinahilat dito ng Supreme Court, the manual signature contained in a printout or photocopy of a documents cannot be considered as information electronically received, recorded, transmitted, stored, processed, retrieved, reproduced as defined under the rules on electronic evidence. Same is true with MCC, Industrial Sales Corporation, but take note, itong MCC provisions ay inabandon na ng Supreme Court in a recent case of Lastimosa case promulgated by the Supreme Court last February lang. So, hindi naman kasama to sa bar questions, but just to highlight, a facsimile transmission cannot be considered as electronic document. However, the Supreme Court has already ruled that this ruling in MCC is no longer applicable. Okay? So, kasi nga, ang photocopy, ang duplicate, ang counterpart are now considered as originals. So, depende sa documents, whether it's electronic or documentary, mayroong rules as regards sa admissibility of a duplicate. Take note also that if there are questions as regards the original document, and it would be unjust to admit the secondary evidence, kailangan original pa rin ang i-present. May exceptions dun sa original document rule. Okay, so the Supreme Court held in this case that text messages presented by the employee were admitted since they corroborate the factual antecedents. Despite the non-authentication, sabi ng Supreme Court, technical rules or procedure may be relaxed in labor cases. So, merong mga ruling ng Supreme Court na medyo lenient sa pag-apply ng technical procedures kapag admin cases, labor cases, kasi yung merong ibang evidence na kailangan. Not necessarily mag-comply completely sa authentication, but if there's at least substantial compliance, the Supreme Court said you don't have to be strict about the technicalities in these kinds of cases. Interest of justice pa din, and make sure that the rights of the laborers, the rights of the persons involved will be observed to serve the demands of substantial justice. Best evidence rule, meron din sa rules on electronic evidence. Same din concept, original document rule. Kailangan i-present mo yung printout that will show or reflect the data accurately. Kasi nga sa evidence, sa electronic evidence, kasama yung mga pictures, pwede siyang makonsider as an electronic evidence. Alright? In the case of Asnar versus Citibank, he presented a printout, no? Si Asnar, he presented the computer printout, but he was not able to prove and authenticate the contents of the printout. That's why his case was dismissed. His claim for damages was dismissed for failure to prove his case. Same is true with opinion rule. Yung kanina din-discuss natin, expert witness, if you are going to require the special knowledge, skill, or experience, you can present an expert witness. Alright? Meron din exception sa hearsay, sa electronic evidence. Yung business records as exception. Kahit yung custodian, hindi siya yung nag-participate, hindi siya yung nag-prepare ng memorandum, his testimony can still be admitted as part of an exception of hearsay evidence. Alright? How to authenticate electronic documents? Of course, the person presenting the document has the burden to prove. If you're the one presenting it, then you have the burden to prove its authenticity and that is compliant pursuant to the rules. But any other manner of authentication, you have to prove by evidence that it is digitally signed, it has undergone appropriate security procedures, and any other evidence showing the integrity and reliability to the satisfaction of the judge. All right? So, chain of custody and integrity documentation, kasama yon. If you're using an electronic evidence, you have to prove that how it was created, how it was transferred, and how it came to the possession of the court. So, as to make sure that it can be trusted by the court, and the court is sure that it came from a valid source, kasi nga, it will be appreciated as evidence. Alright, so these are the factors for assessing evidentiary weight. So take note, these are just part of the rules on electronic evidence, but basically these factors pertain to the integrity of the documents presented to the court. Kasi nga, nowadays, ang electronic evidence ay easily manipulated, especially with the introduction of artificial intelligence and etc. Madali na siyang i-manipulate. Even videos, madali. Kaya may mga factors kinukonsider ng court in accepting and in the admissibility of these kinds of evidence. And how to prove? You file an affidavit of evidence showing the direct personal knowledge of the affiant based on the authentic records and subject to the cross-examination of the deponent. Ayan. So that ends the lecture on evidence. Let us now proceed with special proceedings and special writs. As defined, a special proceeding is a remedy by which a party seeks to establish a status, a right, or a particular fact. The nature of special proceedings, since it pertains to a declaration of status, right, or particular fact, judgment therein are said to be in rem as it binds the whole world. Bar question, example, let's try to answer one of the bar questions involving special proceedings. Sa history, no, ang question sa rem, in relation to special proceedings, mga minsan isa, minsan dalawa, minsan wala. So, pero bihira yung wala. So, just be ready for 2 or 3 questions involving special proceedings. So, Frank and Gina were married on June 12, 1987. Barely a year after the wedding, Frank exhibited a violent temperament, forcing Gina, for reasons of personal safety, to live with her parents. A year thereafter, Gina found employment as a domestic helper in Singapore, where she worked for 10 years. All the time she was abroad, Gina had no communication with Frank, nor did she hear any news about him. While in Singapore, Gina met and fell in love with Willie. On July 4, 2007, Gina filed a petition with RTC Manila to declare Frank presumptively dead so that he could marry Willie. The RTC granted Gina's petition. The OSG filed a notice of appeal with the RTC stating that it was appealing the decision to the CA on questions of fact and law. Is a petition for declaration of presumptive death as special proceedings. Why or why not? The suggested answer, yes. A petition for declaration of presumptive death is a special proceeding. Under the rules of court, a special proceeding is a remedy by which a party seeks to establish a status, a right, or particular fact. Here, the petition for declaration of presumptive death is a remedy by which a party seeks to establish a particular fact, that the presumptive death of a person in order that he may have the right to remarry. Hence, the petition is a special proceedings. Parts of the special proceedings, estate or the settlement of estate. So when we say estate, it refers to the amount, degree, nature, and quality of the person's interest in a land or property, especially real estate interest that may become possessory. A decedent's estate is the real and personal property that a person possesses at the time of death and that passes to the heirs or testamentary beneficiaries. So, pertains to the real and personal property of the decedent that he has a right at the time at the time of his death. So, it's the decedent's estate. So, question, is the prior determination of heirship in a separate special proceeding required before one can file an ordinary civil action to enforce ownership rights acquired by virtue of succession? And the answer is no. In the case of Treyes versus Larlar, the Supreme Court pronounced that unless there is a pending special proceedings for the settlement of estate, the compulsory or intestate heirs may commence an ordinary civil action to declare the nullity of a deed or instrument or for recovery of property or any other action in the enforcement of their ownership rights acquired by virtue of succession without the necessity of a prior and separate judicial declaration of their status. So that's the ruling. The ruling of the trial court shall only be in relation to the cause of action of the ordinary civil action and not then, which is the nullification of a deed of instrument, which is binding only between and among the parties. Where do you file settlement proceedings? The Supreme Court held that the situs of the settlement proceedings shall be the place where the decedent had his permanent residence or domicile at the time of his death. In determining the residence, the factors should be capacity to choose and freedom of choice, physical presence at the place chosen, and the intention to stay therein permanently. So, settling the estate, if the decedent is an inhabitant of the Philippines at the time of his death, whether a citizen or an alien, his will shall be proved or the letters of the administration granted or settled in the RTC or MTCs as the case may be in the province in which he resides at the time of his death. So take note of the amount, when you study civil procedure or the early parts of the civil procedure, you have to be familiar with the amount, the jurisdictional amount in case of estate or intestate proceedings. If he's an inhabitant of a foreign country, the RTC or MTC, as the case may be, of any province in which he had estate. Preferential jurisdiction of the probate court. So the court, first taking cognizance of the settlement, shall exercise jurisdiction to the exclusion of all other courts, exceptions to this rule of preferential jurisdiction. The decedent is an inhabitant of a foreign country. The court of the province in which a part of his estate may be found shall take cognizance of the settlement of the estate, and if intends to deprive a competent court of authority vested therein by law. But as a general rule, the court first taking cognizance shall exercise jurisdiction to the exclusion of all. Presumptive death. When is a person presumed dead for purposes of succession? Person shall be presumed dead if absence and unheard for a period of 4 years, if a person on board a vessel lost during sea voyage, persons on board an airplane, person in the armed forces was taken part, or person was been in danger of death under the circumstances. 4 years yan for the declaration or the presumption of death for purposes of settlement. 5 years naman disappeared after the age of 75, and 10 years absence of the person if the person is 75 years old and below. What will be the effect of reappearance if a person was presumed dead to be dead proves to be alive? He shall be entitled to the balance of his estate after payment of all his debts. The balance may be recovered by motion in the same proceedings. Kasi nga, when you apply for petition for declaration of presumptive death or declaration of death, then the estate will be settled, and they proceed na with the settlement, and then here he reappears, pero na-settle na yung obligations. The dead who reappears will be entitled to the balance, and the balance can be recovered by motion. Extrajudicial settlement is proper when the decedent left no will, and it shall be presumed that the decedent left no debts if no creditor files a petition for letters of administration within 2 years after the death of the decedent, and the decedent left no debts, and the heirs are all of age, or the minors are represented by their representatives, judicial or legal representative, and the parties agreed to divide the estate among themselves. So these are the requirements for extrajudicial settlement. What will be the effect of an oral partition? It will be considered valid and binding upon the heirs. There is no law requiring partition among heirs to be in writing to be valid. So Rule 74, Section 1 provides that it has been held that the requirement that a partition be put in a public document and registered has for its purpose for the protection of the creditors, at the same time protection of the heirs themselves. The object of registration is to serve as constructive notice to others. The 2-year period pertains to any person any heir or other person that has been unduly deprived of his lawful participation in the estate. Such heir or such person may compel the settlement of estates in the courts in the manner provided for the purpose of satisfying the lawful participation. So if there has already been settlement and the estate has been distributed, or the property has already been distributed to the heirs, any person or any heir who has right is given within 2 years. No one appeared, but within the period of 2 years, somebody appears and claims that he has been unduly deprived of his rights, then it may proceed with the settlement, with the court. So there will be a settlement of the estate in the courts in the manner as provided in the rules of settling the estate. So this is the procedure in the settlement or extrajudicial settlement of estate. So divide estate in a public instrument or affidavit of partition, the filing of the instrument or stipulation in an action for partition, publication, distribution of the estate, and the filing of the claims. So ano mangyayari sa natira or sa residue of the estate? The debts will be paid, the expenses, taxes, etc., payment of the bonds, and then application of the executor or administrator or of the person interested in the estate. Questions as to the advancement is determined, then there will be payment of expenses of the partition and the recording of the order of the partition. For judicial settlement, we file before the court. So petition for allowance of will, the court will issue an order for the finding the petition to be sufficient in form and substance, and the creditors or the heirs will be notified through publication and notice, and then thereafter there will be hearing, and after the hearing, the court will issue an order, a certificate of allowance allowing the will, and there will be filing and recording, and if testate, there will be issuance of letters of testamentary, and if intestate, grant of letters of administration. So take note, if there's a will and the court approves the will, then the court will issue letters of testamentary. But if there's no will, the court will grant letters of administration. If there's small value, summary, settlement of estate of small value is applicable, and here the decedent died, testate or intestate, and the value does not exceed 10,000 pesos. We say probate, it refers to judicial procedure by which the will or the testamentary document is established to be valid. So if there's a will, the heirs, the heirs will be filing an action for probate to approve the contents of the will. And no will shall pass either real or personal estate unless it is proved and allowed in the proper court. So, hindi porket ginawa ng decedent yung will, yun na yung susundin. So, yun yung ipepresent sa court, yung will niya, last will niya, and testament, and it must be approved by the proper court. And there are requirements for the validity of a will. Alright? The main issue in probate proceedings would be the determination of the due execution or the extrinsic validity of the will as provided in Rule 75. The probate court cannot inquire into the intrinsic validity of the will or the disposition of the estate by the testator. There are basic requirements for the execution of a will, and that's the purpose of probate proceedings. The witnesses will be presented to prove how it was executed, and the court has to be satisfied that the will was duly executed. Not the intrinsic validity, only the extrinsic validity, where it will be proven that the will was executed pursuant to the rules, pursuant to the will of the testator himself. As a rule, the issue of ownership is an extraneous matter which the probate court cannot resolve with finality. However, for the purpose of determining whether a certain property should or should not be included in the inventory, the probate court may pass upon the title and ownership, but such determination is provisional and not conclusive. and subject to the final decision in a separate action to resolve title and ownership. What will happen if the will be allowed? Subject to the right of appeal, no, the allowance of the will shall be conclusive as to its due execution, to establish conclusively as against everyone and once for all the facts that a will was executed with the formalities required by law. You're familiar already, you are done with the requirements na naaral nyo to the civil code, the civil law. May mga requirements sa paggawa ng will, yung mga requirements. If the court is satisfied, it will allow the will and it will be conclusive as to its due execution. The facts that a will was executed with the formalities required by law and that the testator was in a condition to make a will and is the only purpose of the proceedings for the probate of a will. Requirement of notice and publication. So in allowance and disallowance of a will, there are two notification requirements, both which are mandatory and jurisdictional. Publication in a newspaper of general circulation or the official gazette, and personal notice to the designated or known heirs, legatees, or devisees. Take note that in application for the probate of a will, you have to notify all the concerned parties. What if you don't have the address or the information as regards other creditors or who are interested persons? That's why there's a need for publication, notice and publication, so that it will be compliant, no, to the notice rule that all the interested persons or maybe interested persons will be duly notified through the publication. Under Section 3, publication of the notice of hearing shall be done upon the delivery of the will or filing of the petition for the allowance of the will in the court having jurisdiction. Personal notice shall be served to the designated or known heirs, legatees, and devisees, and the executor or co-executor at their residence. If you notice, no, kailangang inform yung mga concerned parties. Kasi nga, this involves an estate. And the estate will be partitioned, it will be distributed. So, it will be settled. That's why all the necessary notices, all the necessary publication must be complied with by the parties. So what are the grounds for the disallowance of a will? So it shall be disallowed if not executed and attested as required by law, if the testator was insane or mentally incapable to make a will at the time of its execution, it was executed under duress. Please take note of the grounds. If it was procured by undue and improper pressure or influence, signature of the testator was procured by fraud or trick, and he did not intend that the instrument should be his will at the time of the fixing of his signature. Take note, of course, that the testator cannot testify. So that's why there are requirements for witnesses during the during the execution of the will. That's why the one asking for the approval of the will has the burden, no, to prove to present witnesses subject to the appreciation of the court. So madaming grounds for the disallowance if the court is not satisfied and these grounds are apparent, no, then the will be disallowed. Reprobate of a will, on the other hand, pertains to a will already allowed in a foreign country, according to the laws of that country, may be allowed to be filed and recorded by the proper court in the Philippines. So in the case of Palaganas versus Palaganas, the Supreme Court explained that reprobate or reauthentication of a will already probated and allowed is different from the probate where the will is presented for the first time. Reprobate is specifically governed under Rule 77, and in reprobate, the local court acknowledges as binding the findings of the foreign probate court provided its jurisdiction over the matter can be established. So who are the persons incompetent to serve as an executor administrator? For you not to get confused, executor ang tawag sa ina-appoint ng court pag may will, para i-execute yung contents ng will. Pag walang will, ang tawag sa magmamanage ay administrator. So that's the difference between the two terms. So no person is competent to serve as executor administrator who is a minor, not resident of the Philippines, and in the opinion of the court, unfit to execute rather the duties of the trust by reason of drunkenness, improvidence, or want of understanding or integrity, or by reason of conviction of an offense involving moral turpitude. Importante, mapagkakatiwalaan ng executor administrator because this person will be the one to execute the will, the contents of the will, or the desires of the testator or the decedent. That's why the court must be satisfied with the requirements of that testator or that executor administrator. The executor of an executor shall not as such administer the estate of the first testator. In this jurisdiction, one is considered to be unsuitable for an appointment when he has adverse interest of some kind or hostility to those immediately interested in the estate. So it is the duty of the court now to determine who are qualified to become executors and administrators. When a will has been proven allowed, the court shall issue letters testamentary. Yan. And then, issue to the person named as executor. If he is competent, he accepts the trust, then he gives bond as required by the rules. Kailangan ng bond, no? Provided for by the rules. Bakit? Because this executor will be the one to take charge of the implementation of the letters, and merong mga actions na kailangan gawin, kailangan executor's bond to make sure that he will fulfill his obligation as the executor. Instances of issuance of letters of administration. These are the situation when the court may issue letters of administration. Number one, if no executor is named in the will, named executors as incompetent, refuse to the trust, or failed to give bond, and the person dies intestate. The court may also appoint more than one administrator. So under certain circumstances, well settled in Philippine and American jurisprudence, the Supreme Court upheld the appointment of co-administrators to have benefits of their judgment and perhaps at all times have different interests represented, where justice and equity demand that opposing parties or factions be represented in the management of the estate of the deceased, and where the estate is large or from any cause an intricate and perplexing one to settle. Another situation where there can be more than one administrator, where to have all interested persons satisfied and representatives to work in harmony, and when a person entitled to administration desires to have another competent person associated with him in the office. So, grounds for the opposition to the administration: incompetency of the person, on the ground of the contestant's own right to administration, pwede siyang mag-file or ng opposition, written opposition on the appointment of the administration. So, these are the grounds. Difference between letter testamentary versus letter administration. Letter testamentary is issued by the court to the person named as executor. So, take note, issued by the court as executor, and the court finds him to be competent, accepts the trust, and gives the required bond. While letters of administration with the will annex is issued by the court to a competent person to administer the estate if the executor named in the will refuses to accept the office or is incompetent. So kahit may will, the court may issue letters of administration if the named executor refuses to accept the duty or is incompetent. So as mentioned a while ago, there's a will, no? The court will issue letters testamentary. Pag walang will, letters administration. Dito, situation where the court will issue letters administration but attach yung will because the named executor refused to accept the office. So, the court may issue letters of administration. Letters of administration without the will annex is issued by the court to competent person to administer the estate of the deceased who died intestate or with a void will. So what are the grounds for the removal or resignation of the executor administrator? Court may remove or may permit to resign the executor or administrator or in its discretion if he or she neglects to render his account, neglect to settle the estate according to law, neglect to perform an order of judgment of the court, or absconds or becomes insane or incapable or unsuitable to discharge the trust. So these are the grounds, pwedeng tanggalin si executor or administrator or i-allow ang pagre-resign ng executor or administrator. Since they are appointed by the court, the court finds them to be qualified and then they fail to render account, they fail to settle, they fail to perform the order. So that's a ground for removal or resignation. So what now are the powers and duties of the executor and administrator? So ito yung mga powers nila. Number 1, access to partnership books and property, keep building in repair, retain the whole estate to pay the debts and to administer estate not will, bring and defend an action, compound with debtor or deceased and give discharge and foreclose a mortgage. Merong powers ang executor and administrators and their main duty is to administer the estate. Bayaran yung utang, isettle lang lahat, kailangan isettle. At pwede silang magdemanda, pwede rin silang idemanda as an executor and an administrator. Basically, they have the task, to protect the estate, to dispose the property needed, to pay the estate, to pay the debts, and to make sure that the orders of the court will be complied with. Well, how about the claims that may be filed against the estate? All claims for money against a decedent arising from the contract may be filed. All claims for funeral expenses or expenses for the last sickness and judgment for money against the decedent. Let's proceed now with guardianship. Guardianship is a trust relation of the most sacred character in which one person is called a guardian and acts for another called the ward, whom the law regards as incapable of managing his own affairs. So guardianship is designed to further the ward's well-being, to preserve the ward's property, as well as to render assistance that the ward may personally require. That's guardianship, Kinds of guardian, we have 3 kinds of guardians: a legal guardian, the guardian ad litem, and the judicial guardian appointed by the court. So the legal guardian, by provision of the law, without need of judicial appointment, pertains to parents over the persons of minor children, father in the absence of the mother, and with respect to the property of the minor not exceeding 50,000 in value. Guardian ad litem, competent person appointed by the court for purposes of particular action, and judicial guardian, one appointed by the court over the person of the ward to represent in all civil acts and transaction. Sino naman yung incompetent? Yung ward na kailangan ng guardian, suffering the penalty of civil interdiction, hospitalized lepers, prodigals, deaf and dumb who are unable to read and write, those who are unsound mind even though they had lucid intervals, and persons not being of unsound mind but by reason of age, disease, weak mind, and other similar causes cannot take care of themselves and manage the property, becoming an easy prey for deceit and exploitation. So defined under the rules ang incompetent, should there be an application for guardianship. So kailan naman pwedeng ma-remove ang guardian? Guardian becomes ma-remove in such a way na hindi siya allowed to take care of the ward or take care of the incompetent. So when a guardian becomes insane, when a guardian is incapable of discharging the trust, unsuitable, he wasted or mismanaged the estate, and when the guardian failed for 30 days after it is due to render an account or make a return. Not because the guardian has been appointed by the court, he can do everything that involves the property or the money of the ward or the incompetent. So there is twin obligation or responsibility on the part of the guardian to comply and report to the court as regards his status. And if he fails to do that, then he may be removed as guardian. So what are the grounds or petition for the appointment of guardian of a minor? The grounds would be death, continued absence, or incapacity of the parents, suspension, deprivation, or termination of parental authority, remarriage of a surviving parent, or if the latter is found unsuitable to exercise parental authority, and when the best interest of the minor so requires. When to terminate naman? Ano naman yung grounds for the termination of the guardianship? The court, motu proprio, no, or upon motion of any person allowed to file a petition, may terminate the guardianship on the ground that the ward has come of age or has died. So the guardian shall notify the court of such fact within 10 days of its occurrence. So guardianship may be terminated based on this ground. So these are the procedures, no, in the guardianship, in the appointment of a guardian. So filing of petition, notice, order of time and place of hearing. If there's opposition, then the court will conduct hearing, and then upon hearing, the court will issue an order, the appointment of a suitable guardian, then there will be filing of the bond, and then service of judgment. It will be recorded in the local civil registrar, and upon valid grounds, the guardianship may be terminated. Let's proceed now with adoption. Adoption is no longer part of the special proceeding. There's a special rule on adoption. But same thing, no, the adoption is the process of making a child, whether related or not to the adopter, possess in general the rights accorded to a legitimate child. It is a juridical act, a proceeding in rem which creates between two persons relationships similar to that which results from legitimate paternity and filiation. So, of course, what is important in adoption, the court will always consider the best interest of the child. It shall be the paramount consideration in the enactment of alternative care, custody, and adoption policies. This pertains to the new rules on adoption. The special proceedings is no longer applicable because the Public Act has already been promulgated to give the procedure in the administrative adoption. All right, any person, any Filipino citizen at least 25 years old who is in possession of full civil capacity, has not been convicted, can model good moral character, can model the same, emotionally and psychologically capable of caring for children, at least 16 years older than the adoptee may adopt, no? And provided that the requirement of 16-year difference, the adopter and the adoptee's distance, no, yung gap na age, may be waived when the adopter is the biological parent of the adoptee or is the spouse of the adoptee's parent. The legal guardian may also adopt with respect to the ward after the termination of the guardianship and the clearance of financial accountabilities. Foster parent may also adopt with respect to the foster child, and Philippine government officials and employees deployed or stationed abroad, provided that they are able to bring the child with them. Foreign nationals who are permanent or habitual residents of the Philippines for at least 5 years, possessing the same qualification, may also adopt, provided that they come from a country with diplomatic relations with the Philippines and will acknowledge the certificate of adoption as valid, acknowledge the child as legal child of the adopters, and allow the entry of the child into such country as an adoptee. These are the requirements of residency that may be waived. Kasi diba, sabi kanina, foreign national who is a permanent or habitual resident of the Philippines for at least 5 years. So, dito, mawi-waive yun if a former Filipino citizen habitually residing in the Philippines who seeks to adopt a relative within the fourth civil degree of consanguinity or affinity, one who seeks to adopt a legitimate child of the Filipino spouse, and one who is married to a Filipino citizen and seeks to adopt jointly with a spouse relative within fourth degree of consanguinity or affinity of the Filipino spouse. What are the instances when spouses are not required to jointly adopt? If one spouse seeks to adopt the legitimate child of the other, and if one spouse seeks to adopt own illegitimate child, provided that the other spouse has signified consent, or if the spouses are legally separated from each other. Let's proceed now with some of the important writs. In relation to adoption, please take note of the procedures provided under the Republic Act in relation to administrative adoption. So these are just important points needed for you to remember for adoption. So habeas corpus is an order issued by a court directed to a person detaining another, commanding him to produce the body of a person whose liberty is being restrained at a designated time and place. And what for? You ask him to show cause for the continued custody of the person. It is a device, no? It's a writ issued by the court in order to cause the presence or to produce the person. No, that's the writ directed to another, commanding him to produce the body of the person. When is it proper? It shall extend to all cases of illegal confinement or detention by which any person is deprived of his liberty, by which the rightful custody of any person is withheld, except the deprivation of a person's liberty either through illegal confinement or through detention, or withholding of the custody of any person from someone entitled to the custody. How about custody of minors? So, habeas corpus may be resorted to in cases where the rightful custody of any person is withheld from the person entitled. So, in custody cases involving minors, the writ of habeas corpus is prosecuted for the purpose of determining the right of the custody over a child. Habeas corpus in relation to custody. So, the grant of writ depends on the concurrence of the requisites. Petitioner has the right of custody over the minor. The rightful custody of the minor is withheld from the petitioner by the respondents, and it is the best interest of the minor concerned to be in the custody of petitioner and not that of respondent. So, procedure for habeas corpus: filing a petition, grant or disallowance of the writ, issuance of the writ under the seal of court, service of writ, execution and return, and upon the production of the minor involved, there will be hearing by the court, and the officer brings the person before the judge. How about writ of amparo? Second writ would be amparo. It's a remedy available to any person whose right to life, liberty, and security is violated or threatened with violation by an unlawful act, omission of a public official or employee or of a private individual. Shall cover extra-legal killings and enforce disappearances or threats thereof. Extra-legal killings, as defined, are killings committed without due process of law, without legal safeguards or judicial proceedings. This will include illegal taking of life, regardless of the motive, summary and arbitrary execution, salvaging, even of suspected criminals, and threats to take the life of a person who are openly critical of erring government officials and the like. How about enforced disappearances? The Supreme Court identified the elements constituting enforced disappearances, such as there be an arrest, detention, or abductions in any form of deprivation of liberty. That it be carried out by, with the authorization, support, or acquiescence of the state or political organization. It be followed by the state or political organization's refusal to acknowledge or give information on the fate or whereabouts of the person, subject matter of the amparo petition, and the intention for such refusal is to remove the subject person from the protection of law for a prolonged period of time. So that's enforce disappearances, and that's when you file a petition for the issuance of writ of amparo. Writ of habeas data, on the other hand, is a remedy available to any person whose right to privacy in life, liberty, or security is violated or threatened by an unlawful act or omission of a public official or employee or private individual engaged in the gathering, collecting, or storing data or information regarding the person, family, home, and correspondence of the aggrieved party. Very simple, no, yung definition ng writ of habeas data. So take note, ang pinoprotect dito yung privacy in life, liberty, and security violated by the unlawful act nino, public official, employee, private individual who has the duty or engaged in gathering data. Okay, there's always in these kinds of writs there is an impending commission of violation of the rights of these persons involved. So what is a writ of kalikasan? The writ is a remedy available to a natural or juridical person, entity authorized by law, people's organization, non-governmental organization, or any public interest group accredited by or registered with any government agency on behalf of person whose constitutional right to balance and healthful ecology is violated or threatened with violation by unlawful act. Sino? Sino naman taong involved? Public official, employee, private individual, involving environmental damage of such magnitude that will prejudice the life, the health, or property of inhabitants in two or more cities or provinces who may avail writ of kalikasan. File a petition for the issuance on behalf of the person whose constitutional rights to a balanced and healthful ecology is violated, and it may be filed by any of the following: a natural juridical person, entity authorized by law, people's organization, NGOs, or any public interest group accredited or registered with any government agency. What is precautionary principle in relation to writ of kalikasan? So when there is lack of full scientific certainty, precautionary principle rule, between human activity and environmental effect, the court shall apply the precautionary principle. Take note of this principle in resolving the case before it. The constitutional right of the people to a balanced, healthful ecology shall be given the benefit of the doubt. So, the factors that may be considered would be threat to human life or health, inequity to present or future generation, or prejudice to the environment without legal consideration of environmental rights of those affected. So that's really in relation to writ of kalikasan, the court may consider precautionary principle rule. Writ of continuing mandamus, it's a writ issued by a court in an environmental case directing an agency or instrumentality to perform an act or series of acts decreed by final judgment, which shall remain effective until judgment is fully satisfied. Let's proceed now with another kind of special proceeding, change of name, Rule 103. Rule 103, petition for change of name under rule may be filed when a person is seeking to change his or her surname or change both his or her first name and surname. Grounds for change of name: name is ridiculous, dishonorable, or extremely difficult to write. Change results as a leak. Hindi porket hindi mo gusto yung pangalan mo, pwede ka na mag-file ng change of name, ha? Kailangan may grounds. When the change will avoid confusion or one has continuously used and been known since childhood by a Filipino name. When the change is based on a sincere desire to adopt Filipino name, to erase signs of former alienage, when the surname causes embarrassment and there is no showing that the desired change of name was for a fraudulent purpose, and intersexuality is also a ground for change of name. Venue for Rule 103 shall be filed before the RTC province where the petitioner has been residing for at least 3 years prior to the filing of the petition. Rule 108 can be filed. It governs the proceeding for the cancellation or correction of any entry concerning the civil status of persons which has been recorded in the civil register. It covers not only clerical errors but also substantial changes. It implements judicial proceedings for the correction and cancellation of entries. Entries in the civil register refers to acts, events, and judicial decrees concerning civil status of persons, also enumerated under Article 408 of the Civil Code. Difference between a clerical error and substantial error. Of course, clerical error is visible to the eyes or obvious to the understanding. Error made by a clerk or a transcriber or mistake in copying or writing or harmless change such as a correction of name that is clearly misspelled or misstatement of the occupation of the parent. Substantial, on the other hand, pertains to substantial or contentious alteration and may be allowed only in adversarial proceedings in which all interested parties are impleaded and due process is properly observed. Substantial alteration include those that may affect the citizenship, legitimacy, paternity or filiation, or legitimacy of marriage. So, clerical versus substantial. Who has jurisdiction? You file the case or the petition before the RTC of the province where the corresponding civil registry is located. If you fail to implead, kasi the indispensable parties, the rules itself provides that all person who stand to be affected by the substantial correction of an entry in the civil registrar must be impleaded as indispensable parties, and your failure to implead renders all proceedings subsequent to the filing of the complaint, including the judgment, ineffectual. So there's a requirement to implead the indispensable parties. So what are the grounds for the filing, for the cancellation and the correction of entries? These are the entries: birth, marriage, deaths, legal separation, judgment of annulment of marriage, judgment declaring marriages void, legitimation, adoption, acknowledgement, naturalization, election, loss of recovery of citizenship, civil interdiction, judicial determination of filiation, voluntary emancipation of minor, and changes of name. These are the entries that may be subject of correction and cancellation. So, how about RA 9048? So, administrative correction, if you want to change your first name, but it's just a clerical or typographical error in the civil registrar, to change or correct the day or month of the date of birth, correct the sex where it is patently clear that there was clerical or typographical error. So you can avail the correction under RA 9048. No need for judicial approval of the court. So the petition for change of name may be allowed in the following cases. Petition finds a first name or nickname to be ridiculous, tainted with dishonor, extremely difficult to write or pronounce. The first name or nickname has been habitually or continuously used, and the change will avoid confusion. The verified petition must be filed before the local civil registry of the city or municipality where the record being sought to be corrected or changed is kept. So no need for you file it before the local civil registrar. So let's proceed now. Almost last portion ng important points sa special proceedings. A person seeking to change his first name, correct typographical error, to change the day and month of his date of birth, change or correct the sex, where it is patently clear that there was clerical or typographical error, there must be filing of the verified petition with the local civil register registry or office of the city or municipality where the record sought to be corrected is kept in accordance with RA 9048 in relation to 10172. A person may only avail of the appropriate judicial remedies under Rule 103 and Rule 108 in the aforementioned entries after the petition in the administrative proceeding is filed and later denied. So you cannot immediately proceed to the court for judicial cancellation or correction for these items, no? If you fail to secure or to pursue first administrative remedies. So you have to file administrative remedy before the local civil registry, and then if it gets denied, then that's the time that you can ask for judicial remedy and judicial intervention in relation to Rule 103 and 108. So here's the flow chart for Rule 103. File 103 to So file of a signed and verified petition for change of name. The court issues an order fixing a date and place for hearing. Then there's publication, then there's hearing, and the court will issue judgment, and then the judgment will be served. Now, for Rule 108, you file a verified petition for cancellation or correction of entry, then there's notice and publication. The oppositors may be given opportunity to file their opposition, and then thereafter there will be hearing, and there will be order granting or denying the petition. For 9048, in the admin remedy, no, you file before the local civil registry where the record is kept, or in the Philippine consulate where the Filipino citizen resides or domiciled in a foreign country. There will be publication, and then thereafter there will be filing of copies, concerned city or municipal civil registrar or consul general, office of the civil registrar general, and the petitioner. So these are some of the cases that involves the correction. No? So here in Republic versus Ontuca, the issues hinge on the RTC's jurisdiction to order the correction of Annabelle's first name from Mary Annabelle to Annabelle and her middle name to Palino, from Palino to Pelenio, and to change her civil status from married to not married under the provisions of Rule 108 of the Rules of Court. Thus, the Supreme Court found it necessary to determine the scope of the rule and the nature of the errors that Annabelle seeks to correct in the birth certificate. The Supreme Court highlighted that Rule 108 applies when the person is seeking to correct clerical or innocuous mistakes in documents with the civil register. It also governs the correction of substantial errors affecting civil status, citizenship, and nationality of a person. The proceeding may either be summary if the correction pertains to clerical mistakes, or adversary if it involves substantial errors. Here, the Supreme Court said the petition must be filed before the RTC that will set the hearing and direct the publication in the newspaper. Then the RTC may grant or dismiss the petition and serve a copy of its judgment to the civil registrar. After applying these laws, the Supreme Court said that Annabelle's first name should be and surname should be determined whether the correction is substantial or clerical. Ordinarily, substantial means consisting or relating to substance or something that is important or essential. In relation to the change or correction of an entry, substantial refers to that which establishes or affects a substantive right of a person. Thus, changes that will affect the civil status from legitimate to illegitimate, as well as the sex, civil status, or citizenship are substantial in character. On the other hand, 9048, as amended, defines clerical or typographical error as mistake in the performance of clerical work, such as writing, copying, transcribing, or typing the entry in the civil register that is harmless, such as misspelled name or misspelled birthplace, mistake in the entry of the day and month, or in the birth or sex of the person, which is visible to the eyes. Now, guided by that clear principle. Sabi ng Supreme Court, the correction of Annabelle's middle name from Palinio to Pelenio involves clerical or typographical error. It merely rectified the erroneous spelling, substitution of A and I and E, so it will be read as Pelenio. To be sure, Annabelle's unified multipurpose ID shows that her middle name is spelled as Pelenio. Similarly, the error in the first name is also clerical. Neither it will affect or prejudice her substantial rights. So, the postal ID and passport satisfactorily show that her first name is Annabelle and not Mary Annabelle. Referring to Annabelle's records or documents, the errors in her first name and middle name may be corrected under RA 9048. Hence, Annabelle may file the petition to correct her personal information in the birth certificate of her child. The application is not limited to cases in which erroneous entries in the birth certificate sought to be corrected pertain to the owner of the birth certificate. Here, the Supreme Court emphasized that it may be filed under RA 9048 and the correction, however, in the date and place of the parents' marriage from May 25 at Occidental Mindoro to not married is substantial, since it will alter the child's status from legitimate to illegitimate. Ang haba ng ruling ng Supreme Court dito. Mix kasi. Ngayon, so malapit na to. Last na yon. To be sure, the correction of entries pertaining to citizenship, legitimacy of paternity or filiation, or legitimacy of marriage involves substantial alteration which may be corrected, and the true facts established provide the parties aggrieved by the error to avail themselves of the adversary proceedings. Here, Annabelle correctly filed a petition for cancellation or correction of entries before RTC under Rule 108. Nevertheless, Annabelle failed to observe the required procedures under Sections 3 and 4. While tama yung petition, sabi ng Supreme Court, failure to comply with the procedures will also have an adverse effect on the petition. In relation to the cases na penned by the chair, no, in relation to special proceedings. So here's the question. Does RTC La Trinidad Benguet has jurisdiction over local civil registrar of Karangalan, Nueva Ecija, directing the same to cancel the second birth certificate as consequence of its order to correct the party's first birth certificate. So, in the case of Republic versus Felix, Supreme Court reiterated that jurisdiction over the main case embraces all incidental matters arising therefrom and connected therewith under the doctrine of ancillary jurisdiction. The trial court here has jurisdiction over respondent's petition for correction of entries in his first birth certificate on file with LCR Itogon Benguet. The trial court has jurisdiction also to direct the cancellation of the respondent's second birth certificate in LCR Karangalan, Nueva Ecija as an incident or necessary consequence of the action to correct the entry sought by the respondent. Next also a case penned by the bar chair. What is the nature of the petition for correction? It is an action in rem. So a decision binds not only the parties but also the whole world. Third question, does RA 9048 as amended divest RTCs over petitions for correction? The answer is no. No. Even with RA 9048 prescribing the administrative remedy for correction of entries with civil register, the RTC are not divested of their jurisdiction. Even the failure to observe the doctrine of exhaustion of administrative remedies does not affect the jurisdiction of the court. The Supreme Court emphasized that failure to observe the doctrine does not affect, and it was repeatedly stress in the long line of decision that they only affect the only effect of non-compliance is that it will deprive the complainant of cause of action, which is a ground for dismissal. If not invoked at the proper time, this is a ground, or this ground may be waived, and the court can then take cognizance of the case and try it. Who must be impleaded? Who must be impleaded? Rule 108 for cancellation or correction of entries. So the Rule 108 of the Rules of Court outlines the procedure for the cancellation and correction of entries, and the proceedings may either be summary or adversary depending on the correction sought, whether it's clerical or substantial. If the correction is clerical, the procedure to be adopted is summary. Otherwise, it is adversary. Corrections in either name or names of an individual's parents or parents in his birth certificate involve substantial matters which requires an adversarial proceedings. All persons who stand to be affected by the substantial correction must be impleaded as indispensable parties. And that ends the short discussion on the major items and discussions in special proceedings. Take note of the definitions always whenever you answer remedial law questions. And whenever you review remedial law subjects, specifically evidence and SpecPro, alamin niyo yung mga definitions. Makakatulong yan sa inyo. And I hope you will all survive and pass the bar exams. God bless.
Thank you so much po, Judge, for that comprehensive and informative lecture you have shared with us today. It is truly an honor and a privilege for us to have you here with us. And I'm sure that our barristers are being enlightened on the crucial concepts and procedures of special proceedings and evidence. So for this part of the program, we will have some questions for you, Judge. So to start with, this is under the evidence. Judge, can you give tips on how to quickly spot hearsay and its exceptions in bar questions?
Tips on how to determine whether the statement is hearsay? So, if the person testifying is not the one who made the statement or who gave the statement, he's just testifying as regards the giving of the statement, then that is hearsay because he has no personal knowledge. As mentioned kanina during the lecture, let's say, si Mario nag-testify siya, sabi niya, sinabi sa akin ni Maria na siya ay ninakawan. So that's basically hearsay. So for you to easily detect the statement in the question, kung hearsay siya, wala siyang personal knowledge. He's testifying as regards as an incident that he has no personal knowledge of. So, kinuha niya lang yung information sa ibang tao, hence that is hearsay and inadmissible.
Okay po. So, the next question, Judge, what do you think will be the most bar examinable topics under special proceedings?
Correction of entry, pwede, and yung special writs. Special writs yun. Tanong yan. And yung writ of kalikasan.
Okay po. So, during this pre-week period, can you share some tips on how to study smart and some words of encouragement for our barristers, especially most of them, if not all, are overwhelmed and pressured for the upcoming bar exam?
Tips?
Yes.
Okay. Sleep and eat well. Napaka-importante na kakain kayo ng maayos at matutulog ng maayos. Huwag yung gawing dahilan yung pagre-review na kulang kayo sa tulog. All it takes is proper management of your time and priorities. Yes, it's a difficult time of your lives kasi it's something that will determine your future. Passing or not passing the bar, it may or may not determine your future. But what's important here is you know what you want and you're doing your best. You're doing your best to get that title, being called as a member of the bar. And all you have to do, number one, is to pray. Surrender it to God. tell him that you want that dream to become a reality. You want to get that license, get that roll number. Number 2, you organize your things, choose the reviewers. So if you're done with your first and second readings at this point in time, whether it's July, August, or September, by this time you should have one basic reviewer or one basic material to refresh your memory so that it will be your companion at the bar side. So you fix your materials, choose the best reviewer that is talking to you. So there's a lot of reviewers in town, and you have to choose that reviewer that talks to you, that you are familiar, that you are enjoying reading. So yun yung importante. And number 3, before the bar exams, you stop reading, you sleep, and then make sure that you will wake up early for the bar examination itself. I know you can do it. Just trust the Lord and surrender everything to God. Thank you.
Thank you so much po, Judge. Thank you so much po for your time and expertise that you have shared with us. So once again, this is just one of many pre-week lecture series brought to you by PALS in partnership with Rex Education and Central Books PH. Please be reminded, for the upcoming lectures, we have the schedule for legal and judicial ethics and taxation. Do not forget to like and follow the Facebook page of Central Books PH and Philippine Association of Law Schools to remain updated with the dates and speakers for each lecture. We would also like to acknowledge our collaborators and sponsors, Central Books and Rex Education. And most importantly, to you, our aspiring lawyers, for your dedication, focus, and active participation throughout this journey. Stay confident, stay committed, and we'll see you at the oath taking. Again, this is Mary Jane Matalog. Good luck!